ever feel like the legal system is just this giant, bewildering maze?
Oh, absolutely.
You're trying to figure out how justice actually works. Maybe you even need to navigate it yourself, and bam, you're
Yeah.
hit with all this legal jargon, these procedures.
Hmm.
It just feels designed to confuse.
It's a very common feeling, that sense of being completely lost.
Yeah.
And that's exactly why clarity, understanding the how-to of justice really makes all the difference.
Right.
In a world just awash with information, having that clear roadmap, even for complex legal stuff, it can really ease that uncertainty.
Well, that's pretty much our mission today. We're doing a deep dive into some really fundamental procedural parts of India's new criminal code, the Bhartiya Nagrik Suraksha Sanhita 2023. We'll probably just call it the BNSS.
Good idea.
We're looking at things like how trials get sped up, how certain deals or agreements can be reached, the very specific rules for getting people who are already confined into court,
Hmm.
and maybe most importantly, how evidence actually gets gathered and recorded.
Our goal here is really to pull out the crucial bits, the important nuggets,
Yeah.
to sort of demystify these pretty intricate legal mechanics and hopefully give you that aha moment.
Exactly.
We've got the BNSS sections right here, our source material, and we're just going to guide you through what really matters in these parts.
Specifically, we're focusing on the chapters covering summary trials, plea bargaining, the attendance of persons confined in prisons, and some key bits from the big chapter on evidence and inquiries and trials.
Right. And each of these areas, they offer really unique insights into how the system is pushing for efficiency, but also trying hard to maintain those essential safeguards.
The foundations of fair and fast justice. Summary trials.
Okay, let's jump right in then. Summary trials. The name itself sounds fast, right?
It does.
But what does that actually mean for someone, facing charges? How does this quicker process really work under the new code?
It's an interesting balancing act, really. This first part we're looking at, Chapter 22,
Hmm.
it lays down the basic rules for these faster trials.
Huh.
And maybe the most crucial thing to take away, it puts a hard, absolute limit on the maximum jail time you can get.
A hard limit. Okay. So on one side, you've got speed. The procedure for these summary trials, it generally follows the rules for what are called summons cases.
Right. Typically, less serious offenses.
Yeah, less serious stuff. It's much less elaborate than a warrant case trial, which is for the more serious crimes and involves, formal written charges and all that.
Exactly. So this streamlining, it's clearly designed to get minor disputes resolved quickly.
So you're bypassing a lot of the detailed steps you'd see in a more complex trial. The core accusation still has to be clear, obviously.
Oh, absolutely. The substance of the accusation must be stated. But the process is definitely leaner.
Right.
And then, like you said, there's that critical safeguard. The law explicitly states, for any conviction under this chapter, the maximum imprisonment cannot be more than 3 months.
Wow, 3 months. That
Yeah.
cap feels pretty significant, doesn't it?
It really is.
It means even if, say, a regular trial for the same offense might normally carry, I don't know, a year in prison, if it ends up being handled as a summary trial, maybe because the magistrate decides it's appropriate, that person is guaranteed they won't get more than 3 months. It just drastically cuts down the potential sentence.
And what's really insightful here, I think, is how that 3-month cap fundamentally shifts the strategic thinking.
How so?
Well, for the accused, it turns what could be a long, drawn-out ordeal into something more manageable, more time-bound. It often gives an incentive for a quicker resolution.
Okay.
And for the justice system itself, it acts as a critical pressure valve.
Yeah.
It stops minor cases from clogging up court time and resources that are really needed for more complex matters.
So what does this all mean for you, our listener? If you or someone you know gets caught up in a minor legal issue that goes to a summary trial, you get the benefit of a faster resolution, plus that guaranteed ceiling on potential jail time.
Right. It's designed, really, to reduce the anxiety about super long proceedings and punishments that might feel out of proportion for minor offenses.
And this isn't a totally brand new idea, is it?
No, not at all. Similar ideas existed in the previous criminal code, the CRPC. And court decisions over the years have consistently backed the idea that the intention here is swift disposal of less serious cases.
Right.
Implicitly acknowledging how important both efficient procedure and these kinds of sentencing limits are.
Which brings us to that key tension, I guess.
Exactly. How do courts consistently balance this undeniable need for speed and efficiency with, the fundamental right everyone has to a fair hearing, even if the potential sentence is relatively short?
That 3-month cap feels like a very direct legislative attempt to answer that.
It does.
Okay, so speed is one thing,
Mhm.
but how does the court keep track of everything in these fast-paced summary trials? I mean, even quick decisions need some kind of record, right? You can't just wing it.
Absolutely not. And one of the fascinating things about the new code, the BNSS, is how much it insists on a clear record, no matter how quick the trial. Accountability is still paramount.
Right.
So even in a summary trial, the magistrate must, it's not optional, meticulously record specific details, specific particulars.
So it's not just jotting down guilty or not guilty. The law actually requires a mandatory entry, and the magistrate has to follow a specific form, one laid out by the state government.
Precisely. It's not an optional step at all. And the particulars they have to record are surprisingly comprehensive for what's supposed to be a summary proceeding.
Like what?
Well, everything from the case's serial number, the date of the offense, date the complaint was filed, names of the complainant, the accused, right down to the specific offense that was alleged and, crucially, the offense that was actually proven.
Okay.
And for certain types of cases, like some theft cases, even the value of the property involved needs to be noted down.
And it doesn't stop there, does it? It goes on to include the accused's plea guilty or not guilty, any examination they went through, the court's final finding, the sentence or the final order, and the exact date the case wrapped up.
That's quite a paper trail, even for a summary trial.
It really is.
Let's imagine Magistrate X is handling a case of petty theft. Maybe an item worth, say, 500 rupees.
Okay.
The record wouldn't just be a simple guilty. No, it would meticulously detail the case number, the dates, the accused Y's full name, parentage, the specific theft charge under the new BNS code, the item's value,
The plea.
Y's not guilty plea, a summary of the evidence that was presented, the court's guilty finding, the exact sentence, maybe a fine, maybe 7 days in custody,
Yeah.
and the precise date the case terminated.
Wow.
This level of detail, even though it's brief compared to a full trial record, it ensures transparency.
So what does this mean for you? If you're involved, it means there's a verifiable account, a clear paper trail you can refer back to. And for anyone just observing the justice system, it shows those fundamental elements of due process in action. It helps prevent arbitrary decisions and sets up at least a minimal basis for any later review.
And this commitment to a detailed record, even for these faster cases, it really underscores how important that record is for the validity of the decision and for any review.
Yeah.
Which makes you ask, how does this minimum record still allow higher courts to properly review decisions, especially when individual liberty is potentially at stake, even in these supposedly minor cases?
The integrity of that documented trail seems absolutely crucial for the whole system.
It really is.
Okay, it's good to know there's a record. But what if you plead not guilty in a summary trial? Does the court still have to explain why it reached its decision, or is it just a quick verdict?
That's a really vital point, and the new code, the BNSS, is very clear on this. Even in a fast-track summary trial, if the accused maintains their innocence, the court must provide reasons for its judgment.
No guesswork allowed.
No guesswork. So this part of the law, Chapter 22,
Right.
again, it specifically lays out the essential components of the judgment only when the accused hasn't pleaded guilty.
Right, because that's where the actual legal contest happens.
Exactly. In that scenario, the magistrate can't just state the verdict. They have a clear duty to record the substance of the evidence presented.
Meaning the key parts that swayed their decision?
The essential parts, yes.
Uh-huh.
The bits that influence the decision. And then they have to deliver a judgment that includes a brief statement of reasons for their finding.
Okay.
It's a crucial step to make sure the decision isn't just arbitrary.
Let's picture Z facing a summary trial for, say, simple hurt. Z pleads not guilty. After hearing from witnesses on both sides, the magistrate's judgment wouldn't just say guilty. It would need to summarize the key points from the testimonies, capture the substance, and then briefly explain why. Like, based on consistent prosecution testimony that wasn't rebutted, the court finds Z guilty.
That concise explanation, that's the brief reasons part, and it's fundamental to natural justice. For you, as the accused, it means a conviction or acquittal isn't just some pronouncement from on high. It's a reasoned decision, however concise. You get to understand why the court reached its conclusion.
Which is critical for procedural fairness, for trust in the system.
Absolutely.
Mhm.
And this principle, it echoes similar rules from the old code. Courts have always emphasized that a judgment without reasons, even in a summary trial, suggests a lack of proper thought, a lack of application of mind.
It really makes you wonder, though, how brief can those reasons be before they actually start to undermine the transparency and justice they're supposed to uphold?
It's a very fine line, isn't it?
It seems like it.
Okay, finally, for this chapter on summary trials, let's touch on the practicalities, language, administrative support. Even these details are meticulously covered in the new code to make sure the system actually functions smoothly.
Right, because the mechanics matter. So this section outlines language requirements for the records and judgments, and it allows for help in preparing them, but under specific rules.
Exactly. It's about clarity and efficiency in the background processes. A key point is that the language used for all records and judgments must be the official language of the court.
Okay.
This ensures consistency, makes records understandable for everyone involved, parties, lawyers, the public, higher courts reviewing the case. And it's the state government that determines this official language for its courts.
And you mentioned administrative help.
Yes, there's a practical provision for that. High courts can authorize magistrates to use an officer usually appointed by the chief judicial magistrate to help prepare these records or judgments.
That sounds like a sensible solution for busy courts, just helps with the workload.
It is. It's a pragmatic administrative measure. But, and this is important, while it provides help, the ultimate judicial responsibility always stays with the magistrate.
They still have to own it.
They have to personally sign the document. That signature authenticates its accuracy and confirms it's their decision, their approval.
So imagine a court in a region where, say, Marathi is the official language. All the summary trial records, the judgments, they have to be in Marathi.
Right.
Now, to help with the volume, the chief judicial magistrate might appoint a clerk to type up the record as the magistrate dictates it. But crucially, the magistrate must still sign that typed document, personally vouching for its accuracy and confirming it reflects their judgment.
So what's the takeaway for you here? It means transparency and accessibility. Justice isn't just the outcome, it's also understanding the process in a language you get.
Right.
And that administrative efficiency piece means cases hopefully don't get stuck just because of paperwork, allowing for a smoother, faster process overall.
This seems to follow similar ideas from the old code, too, underlining that even administrative details are vital for the record's authenticity.
Absolutely. Which leads to a lingering question. How do we make sure that this administrative support, while great for efficiency, never, ever compromises the integrity of the decision or the individual judicial thought process that needs to go into every single case?
A new path to resolution: plea bargaining.
Okay, let's shift gears and unpack this next big one, plea bargaining.
This concept has, well, it's really reshaped how certain criminal cases get resolved, hasn't it?
It certainly has.
Offering a potentially faster route to justice for many, but it's definitely not a free-for-all, is it? There are rules.
Absolutely not. And what's fascinating here is how the new code, the BNSS, in Chapter 23, has very carefully sculpted this mechanism. It's designed to be both efficient and equitable, but with really clear boundaries and safeguards.
It's like a structured way to manage the system's load, but under strict controls.
That's a good way to put it.
So to understand it, we need to know who can actually make a plea bargain. This gets us into the scope and, maybe more importantly, the crucial exclusions. What kinds of cases are even eligible?
Right. So it applies to accused people facing charges that come either from a police report or a private complaint. But here's the big limitation. It's only for offenses that are not punishable with death, life imprisonment, or imprisonment for more than 7 years.
7 years. That's the threshold. That's the key threshold. It's fundamental. It ensures plea bargaining is kept for, let's say, less heinous offenses. You're not bargaining away the most serious crimes.
That makes sense. And the code specifically carves out some major exclusions too, doesn't it? It doesn't apply to offenses that affect the socioeconomic condition of the country.
Correct.
Or crimes committed against a woman, or crimes committed against a child.
Yes, those are significant policy choices reflected right there in the law. These exclusions show a strong decision to treat crimes with broader societal impact or those involving vulnerable victims with the utmost seriousness. They demand a full trial, not a negotiated settlement.
And to avoid confusion about what counts as socioeconomic, the central government is supposed to issue notifications.
Exactly. They shall notify which offenses fall into that category. This provides clarity, prevents arbitrary decisions, and promotes consistency across the country.
Okay, let's make this concrete. If someone's charged with simple theft, say max 5 years prison under the BNS,
Yeah.
they'd generally be eligible for plea bargaining, right?
Generally, yes, assuming no other disqualifying factors.
But contrast that with someone charged with a very serious offense, like rape.
Not eligible. That's explicitly an offense against a woman, falling squarely into those exclusions.
Or maybe someone accused of a huge financial scam that the government has specifically notified as a socioeconomic offense.
Also not eligible.
Okay. So what does this mean for you? If you're an accused person, these clear rules tell you right away if plea bargaining is even an option for your specific charge.
Right?
And for society as a whole, it gives confidence that serious crimes aren't just being swept under the rug through negotiation. It maintains public trust.
And these provisions, they align with how courts viewed similar concepts before. The emphasis is always that plea bargaining must serve justice, not create an impression of, compromising on serious matters.
Yeah.
Which raises an important ongoing question. How do we continuously evaluate and refine these exclusions? Do they accurately reflect evolving societal values and justice priorities, especially as new types of crime or vulnerabilities emerge?
Okay, so let's say you are eligible for plea bargaining. How do you actually start the process? And maybe even more critical, how does the system make sure you're not being pressured into a deal you don't really want?
Yes. This brings us to voluntariness. It is the absolute bedrock, the foundation of the entire plea bargaining process. This section of the code, Chapter 23, it lays out the precise steps an accused must take and fundamentally emphasizes that it must be a voluntary, informed choice.
Okay, so the accused has to file an application in the trial court. Is there a specific time window for that?
Yes, there is. The application has to be filed within 30 days from the date the charge against them is framed. It's a fairly tight deadline.
30 days. Okay.
Yeah.
And the application itself, it's not just a simple note.
No, it needs to be quite specific. It has to include a brief description of the case and, very importantly, an affidavit sworn by the accused themselves.
An affidavit, what does that need to say?
It has to explicitly state three key things. 1, the application is entirely voluntary. 2, the accused fully understands the nature and the extent of the punishment for the offense. And 3, the accused has not previously been convicted for the same specific offense.
That same offense bar again. So it stops repeat offenders for the exact same crime from constantly using plea bargains.
Precisely. It prevents habitual offenders of a specific crime from gaming the system.
Okay, so the application with the affidavit is filed. What's the court's next move?
The court issues a notice to the public prosecutor, or the complainant in a private case, and the accused, setting a date. But then comes the most critical safeguard, an in-camera examination.
In camera, meaning private.
Yes, private. The court examines the accused alone, without the other parties present, specifically to verify that their application for plea bargaining is genuinely voluntary, that they haven't been coerced or unduly influenced.
That private chat with the judge sounds like a really crucial protection for the accused.
It absolutely is. If the court is satisfied it is voluntary, it then gives the parties a set amount of time, up to 60 days, to try and work out what's called a mutually satisfactory disposition, or MSD.
Okay.
And this MSD may even include victim compensation, which is a nod towards restorative justice. The court then sets a date for a further hearing.
But what if the judge isn't convinced it's voluntary? Or finds out about that prior conviction for the same offense?
Then the application is rejected flat out, and the trial simply picks up from where it left off when the application was filed. Crucially, this happens without any prejudice to the accused.
Okay, let's visualize this. Accused A, facing an eligible charge, files the application within that 30-day window. A's affidavit clearly states, voluntary, understand the punishment, no prior conviction for this specific offense.
Right.
The judge then takes A aside, speaks to them privately in camera, confirms A isn't being forced. If satisfied, the judge says, okay, you and the public prosecutor have, say, 45 days to discuss terms. And those terms might include A, compensating the victim.
Exactly. So what does this mean for you? The whole process is meticulously built to protect the accused. That in-camera examination is your ultimate shield against coercion, making sure the choice is truly yours.
And the chance for victim compensation adds that restorative justice angle.
It does. It reflects how important courts consider genuine voluntariness and the accused fully understanding the deal, which again makes us ask, how can we ensure voluntariness is deeply understood not just by courts, but by everyone involved, including legal aid lawyers, to truly empower the accused in this process?
Right, so the application's in, the court's happy, it's voluntary. What next? Do the parties just, go off and haggle somewhere?
Oh, no, not at all. The court actually retains a really crucial role here as an impartial facilitator.
Okay.
And this is key. It makes sure the process stays structured, stays fair, even when they're trying to strike what is essentially a bargain. The new code is quite clear on how the court guides this negotiation.
So the court actually facilitates a meeting, brings the relevant people together to reach that mutually satisfactory disposition, the MSD.
Precisely. The code specifies who needs to be there. If the case started from a police report, you need the public prosecutor, the investigating police officer, the accused with their lawyer, and very importantly, the victim.
The victim is present. Okay.
And if it's a case based on a private complaint, it's the accused with their lawyer and the victim.
So the court isn't dictating the terms of the deal,
No.
but acting more like an overseer, ensuring fairness. The law actually says it's the court's duty to make sure the whole MSD process is completed voluntarily by everyone involved.
That's the critical difference. The court facilitates, it doesn't participate in the actual negotiation itself. Its oversight is vital to prevent coercion or maybe misleading information being exchanged.
Yeah.
And having the victim there, as we mentioned, that's particularly noteworthy. It pushes towards a more restorative justice outcome, ensuring their voice is heard and their interests are considered directly.
Okay, back to accused A. Their voluntary application is accepted. The court calls a meeting. Since it's a police case, you'd have the public prosecutor, the investigating officer, A with A's lawyer, and the victim, V, who might also bring their own lawyer.
Right.
And they discuss terms. Maybe A pleads to a lesser charge, agrees to a specific sentence, and definitely agrees on compensation for V. The judge watches over this, ensures it's fair and voluntary, but doesn't impose the terms.
Exactly. So what does this mean for you? If you're a victim, this gives you a direct way to have your voice heard and potentially get compensation included as part of the resolution.
Right.
If you're the accused, it provides a structured, fair environment for a real negotiation, not just some arbitrary decision forced on you.
It echoes what the courts have said about needing voluntariness and the court playing that active, impartial role.
It does, which raises another important point. How do we really empower victims to fully participate, make sure their interests are genuinely represented and considered so their presence isn't just, a box-ticking exercise?
Good question. So after all these discussions, what's the formal outcome? Is it just a handshake or is it more official?
It has to be official. This part of the new code formalizes the result of those MSD meetings. If they reach an agreement, it requires a signed report. If they don't, it's back to a regular trial.
Okay, so if an MSD is worked out successfully, the court prepares a formal report detailing that agreement. And this report needs signatures from everyone involved: the judge, the prosecutor or complainant, the victim, the accused, their lawyers.
Yes, that comprehensive signing is vital. It shows everyone agrees, ensures accountability, and gives the resolution real legal weight.
But what if, after all the talk, they just can't agree? No MSD.
Then the court simply records that fact, makes an observation that no agreement was reached, and the trial just picks up exactly where it left off before the plea bargaining application was even filed.
Okay, let's use our example again. Accused A and victim V, along with the public prosecutor, agree. A pleads guilty to a lesser charge, gets 1 year, pays V 50,000 rupees compensation. The court drafts a formal report with all these terms. Then the judge signs it, A signs it, A's lawyer, the PP, V's lawyer, everyone signs. It becomes a formal, documented deal.
But if they couldn't agree on the term,
The judge just notes no agreement reached and sets the case down for a full trial, just as if plea bargaining had never happened.
Exactly. So what's the bottom line for you? Transparency and accountability. A formal signed report gives legitimacy to the deal.
Yeah.
And crucially, if the bargain falls through, you, as the accused, aren't penalized. Your case just continues. That's a vital protection.
That ability to revert to trial without prejudice seems like a really important safety net. It encourages people to explore plea bargaining without fearing they'll be worse off if it doesn't work out.
It does. Which brings up another thought. How do we ensure the terms agreed upon aren't just mutually satisfactory, but also truly uphold broader principles of justice and the public interest? It's a delicate balance. Right, so once that mutually satisfactory disposition is finalized and signed off, the next step is sentencing. But, as you hinted, this isn't just a standard sentence calculation.
No.
No. What's really fascinating here is the specific structured leniency that's explicitly built into the BNSS for cases resolved through plea bargaining.
Structured leniency.
Okay.
So the code details exactly how the court handles sentencing after an MSD. It prioritizes victim compensation first.
Yes, absolutely. First and foremost, the court must award compensation to the victim as agreed in the MSD. This really highlights that restorative justice aspect.
Okay.
After that, the court hears arguments from both sides on the actual sentence quantum, and it considers options like probation, admonition, or applying the Probation of Offenders Act.
And then we get to these specific sentencing reductions you mentioned, the structured leniency part.
Exactly. For cases where the law prescribes a minimum punishment,
Like, say, a mandatory minimum of 2 years.
right. In those cases, the court may sentence the accused to half of that minimum.
Half.
But wait, there's more. If the accused is a first-time offender,
Ah.
the court can reduce it even further, potentially sentencing them to just 1/4 of that minimum punishment.
Wow, 1/4 of the minimum for a first-timer. That's significant. What about cases without a minimum sentence?
For other eligible cases, those without a prescribed minimum or ones not covered by probation laws, the court may sentence the accused to 1/4 of the maximum punishment provided for the offense.
Okay, 1/4 of the max.
And again, that extra benefit for first-time offenders, they might be sentenced to just 1/6 of the maximum punishment.
1/6.
These precise fractions, half, quarter, sixth, they provide a very powerful, very clear incentive for plea bargaining, especially for first-time offenders. And they give clear guidance to judges, which helps promote consistency.
Let's run that scenario again. MSD reached. A pleads guilty. Offense has a minimum of 2 years, max of 5. A is a first-time offender.
Okay.
First, victim compensation is awarded. Then, under the code, the court may sentence A to 1/4 of the minimum, so just 6 months.
Potentially, yes. 6 months instead of the mandatory minimum 2 years.
Now, what if the offense had no minimum, but a maximum of 4 years? A is still a first-time offender.
In that case, A might get 1/6 of the 4 years, which works out to about 8 months under that other clause.
These are really tangible benefits.
They absolutely are. So what does this mean for you? It offers a substantial, concrete advantage for cooperation, especially if you're a first-time offender. It can dramatically cut potential prison time, offering a much clearer path forward and faster closure.
It seems like it aligns with a more reformative approach to sentencing in these specific cases.
It does. Courts are expected to follow these statutory formulas strictly, which does raise an important practical question. Could this structured leniency unintentionally create an unfair advantage? Maybe favoring those who can afford better legal advice to navigate the plea bargaining process effectively, potentially leaving others behind.
That's a fair point. So once the sentence is decided via plea bargain, is that really truly the end of the line? No more appeals, no challenging it later.
That's essentially the goal. The whole point of a plea bargain from a system's perspective is certainty and finality, to resolve cases definitively and efficiently. This part of the code really cements that.
Okay, so the judgment has to formally reflect the plea bargain terms, be delivered publicly in open court, signed by the judge, standard procedure for transparency.
Right, and then comes the critical part. Once that judgment is made, the new code declares it final. And here's the key phrase. No appeal shall lie in any other court against such a judgment.
No appeal. That's a very strict bar.
It is. It's designed specifically to reinforce the certainty aspect of the bargain. But it's not an absolute hermetic seal. It doesn't affect your constitutional right to file a special leave petition, SLP, to the Supreme Court.
Under Article 136.
Correct. Or a writ petition to the High Court under Articles 226 and 227.
So those fundamental constitutional remedies remain available, but only for really extraordinary situations, like gross injustice, fundamental rights violations, not just for trying to renegotiate the deal you already agreed to.
Exactly. It's not a back door to appeal the agreed terms.
Let's illustrate. Accused A gets sentenced to 6 months via plea bargain. Judge pronounces it, signs the judgment in open court. A cannot then file a standard appeal against that sentence or conviction.
Correct.
However, if A genuinely believes the entire plea bargaining process was fundamentally flawed, say, vitiated by serious fraud or coercion that the trial court completely missed, A could potentially seek review through a writ petition in the High Court or maybe even an SLP in the Supreme Court, arguing a violation of fundamental rights or process.
Yes, those constitutional avenues remain, but the bar is high. So what does this mean for you? It offers a definite end to the legal proceedings, bringing closure much faster.
Huh.
But it also underscores how crucial it is to be absolutely certain about your decision before agreeing to the plea bargain, because your options to challenge it later are extremely limited.
The legislative push for finality is clear.
Very clear. Constitutional interference is meant to be narrow for fundamental flaws only, not just second-guessing the bargain, which does make you ponder, how does a system prioritizing finality deal with those rare but critical instances where truly new, compelling evidence might surface after a plea bargain is completely finalized?
Now, during the plea bargaining process itself, are the court's hands tied in other ways? Does it lose its usual powers? What about time someone might have already spent in jail before the bargain?
Good questions. No, the court absolutely retains its full authority throughout the process. The code makes that clear. And yes, critically, any time already spent in pretrial detention must be credited against the final plea bargain sentence. This section also does something else important. It gives the plea bargaining chapter an overriding effect over any inconsistent parts of the new code, and it clarifies who counts as a public prosecutor for these purposes.
So the court still has all its normal powers regarding bail, handling other aspects of the trial, general case disposal. Plea bargaining is like a special track.
Yeah.
But it doesn't diminish the court's overall control.
That's right. It ensures continuity and effectiveness. And on the fairness side, the code explicitly mandates that pretrial detention time must be set off against the plea bargain sentence. That's a vital fairness provision.
Giving credit for time served.
Exactly. Then there's this important overriding effect clause. If a general rule somewhere else in the BNSS conflicts with a specific rule in the plea bargaining chapter, the plea bargaining rule takes precedence.
Okay, so this chapter's rules win out in case of conflict.
Yes. And it also clarifies that for this chapter, the definition of public prosecutor includes assistant public prosecutors, or APTs.
Why is that significant?
It's practical. APPs often handle cases in magistrate courts. Including them here makes the plea bargaining process more accessible and efficient at the grassroots level, where many of these eligible cases are handled.
So putting it together,
Yeah.
while accused A is exploring plea bargaining, they can still apply for bail, and the court decides that bail application just like normal.
Correct. Plea bargaining doesn't suspend other rights.
And if A is sentenced to, say, 1 year through the bargain, but they already spent 3 months locked up as an under trial?
They only serve the remaining 9 months. The 3 months are automatically credited.
And if some general rule clashes with a plea bargaining rule, the plea bargaining rule prevails. Plus, an APP can officially represent the state in these negotiations.
Absolutely. So what's the key takeaway for you? You don't lose out on other legal rights, like applying for bail, just because you're exploring a plea bargain. And crucially, any time you've already served counts towards your sentence. It's about fairness.
That set-off for time served is a recognized right.
It is. And the overriding clauses are standard practice for special procedures to ensure they work as intended. Which leads to a practical thought. How does specifically including APPs in the definition here enhance the efficiency and accessibility of plea bargaining, particularly at that local magistrate court level?
Right. Now, this plea bargaining system sounds generally well-structured, but what if the deal falls through? Can anything said during those negotiations be used against the accused later if the case goes to trial?
A critical question.
And what about young offenders? Do they use this same adult plea bargaining system?
These are absolutely crucial protections, and the new code provides very clear boundaries here, ensuring fairness and upholding specialized justice principles for juveniles. It covers what happens if negotiations fail, and it explicitly excludes young offenders.
Okay, so the code protects the accused by stating that anything they say in a plea bargaining application cannot be used against them for any other purpose.
Yes, that's a vital safeguard. Any statements made, any facts disclosed within that plea bargaining application shall not be used for any other purpose except for the plea bargaining process itself. Chapter 23.
It creates a kind of safe zone.
Exactly. A safe zone for the accused to explore plea bargaining without the fear that admitting something during negotiations will come back to bite them if the deal doesn't happen and the case goes to a full trial. It avoids self-incrimination in that context.
And for young offenders, juveniles or children.
The code is explicit. They are completely excluded from this entire plea bargaining framework.
Okay.
It states clearly that nothing in this chapter applies to any juvenile or child as defined by the Juvenile Justice Act, 2015.
So it upholds the separate juvenile justice system.
Absolutely. It maintains that distinct philosophy, which is rehabilitative, child-centric, keeping it entirely separate from the adult criminal justice system's plea bargaining mechanism.
Still straight. Accused B makes certain admissions or statements in their plea bargaining application. If, for whatever reason, no MSD is reached and the case proceeds to trial, the prosecution is legally barred from using B's statements from that application as evidence against B in the trial.
Correct. And if a 16-year-old is accused of an offense, even one that, if committed by an adult, would be eligible for plea bargaining, they cannot use these Chapter 23 provisions. Their case must be handled under the Juvenile Justice Act.
Period. They fall under that specialized protective framework.
Unequivocally. So what's the bottom line for you? For adults, it's reassurance that exploring a plea bargain is a consequence-free option if it doesn't pan out. You're not penalized for trying. For juveniles, it means they are definitively under a specialized protective legal system, not the adult one.
That confidentiality of plea bargaining talks and the exclusion of juveniles seem like really important principles.
They are aligning with established legal thought and international child rights standards. Which poses a final thought for this section. How does maintaining this clear distinction between adult plea bargaining and the separate juvenile justice system effectively ensure both goals are met, swifter resolution for eligible adults, and upholding the paramount interest and specific needs of the child in juvenile cases?
Bringing the confined to court. Prison attendance rules.
Okay, let's tackle a really practical challenge the justice system faces all the time. What happens when someone is already locked up, maybe serving a sentence or awaiting trial for one case, but they're needed in court for a different matter, maybe as an accused in another case, or even just as a witness?
Yeah.
It can't be as simple as just, opening the cell door and letting them walk over, can it?
Oh, absolutely not. It's far from simple. And this is an area where the new code, the BNSS, provides a very precise legal framework. It's meticulously balancing the court's genuine need for that individual's presence against really complex concerns, security, public order, the rights of the person who's confined.
Right.
This part of the code, Chapter 24, it actually starts by expanding the definitions of who counts as detained and what counts as a prison. And then it empowers criminal courts to summon these individuals.
Okay, so broadening the scoop first. Detained and prison get wider definitions just for these rules.
Exactly. Detained now explicitly includes people held under any law, even preventive detention laws, not just standard criminal custody.
Okay.
And prison is expanded beyond just traditional jails to cover a whole range of facilities, subsidiary jails, reformatories, borstal institutions for young offenders, things like that.
So these rules apply very broadly.
They do. It ensures the rules apply comprehensively, no matter the specific type of custody.
And then the courts get the explicit power to order these confined persons to be brought before them, whether it's to answer a new charge, participate in proceedings, or just give testimony.
That's right. During any inquiry, trial, or other proceeding, if a court decides it's necessary, it can issue an order directly to the officer in charge of the prison.
Telling them to produce the person.
Yes, either to answer a charge or for proceedings against them or simply to be examined as a witness. But, and this is a vital check, there's an oversight mechanism, particularly for more junior judicial officers.
Okay.
An order issued by a magistrate of the second class requires a countersignature from their superior, the Chief Judicial Magistrate, CJM, before it's valid.
Ah, so the CJM has to approve it. It acts like a check.
Exactly. And to get that countersignature, the magistrate has to submit a statement justifying why the order is necessary. The CJM can actually review that justification and decline to countersign if they aren't convinced.
That seems like a sensible control, preventing potentially unnecessary movements, which obviously involve security risks and administrative hassle.
It is. It prevents unnecessary production orders.
So let's paint a picture. Someone held under a preventive detention law, maybe in a special facility, they're still considered detained under these rules. A criminal court can summon them.
Right. Or a young offender in a borstal institution, same rules apply, they can be summoned.
Or consider accused A, already serving a sentence in jail X, but needed in court Y for a completely new charge. The magistrate in court Y issues an order for A's production.
Okay.
Now, if that magistrate is a second-class magistrate, they need to get their CJM's countersignature on that order, backed by a statement explaining why A's presence is essential.
Precisely. So what does this mean for you? It confirms the justice system can function and bring people to court even if they're already confined. If you're a prisoner, it means your presence can be legally mandated, but there are important procedural checks, especially if the order comes from a lower-ranking judge.
It's about ensuring the accused's right to be present at their trial is upheld, even if they're already in prison.
While also acknowledging the real-world practicalities of security and administration. Which leads to a key question. How does this intricate system, with its checks and balances, effectively guarantee that fundamental right to be present without creating undue risks or administrative nightmares?
Okay, so courts have the power to summon prisoners, but can anyone else step in and just say, nope, this prisoner isn't leaving the jail? Can the government override the court?
Absolutely. And this is where it gets particularly nuanced. It really highlights that critical balancing act between judicial power and executive concerns, things like national security, public order.
Right.
And the prison officer themselves, they act almost like a gatekeeper in this situation because the law gives them very specific legal grounds to refuse to comply with a court's production order.
So the state or even the central government can actually issue an order that overrides a court's summons, prohibiting a prisoner's removal. That sounds like a significant executive power.
It is an extraordinary power, yes. The government, state, or central can, by a formal order, direct that a specific person, or even a whole class of persons, shall not be removed from the prison where they're held. And that government order effectively nullifies any court order under Section 302 trying to summon them.
What factors would they consider?
The law says they must consider the nature of the offense the person is charged with, or the grounds for their confinement, the likelihood of a disturbance of public order if that person were removed and transported, and the general public interest.
So typically for high-risk situations.
Exactly. Think gang leaders whose appearance might spark violence, or individuals deemed serious security threats where transport itself is risky.
Okay. And the prison officer themselves also has specific, legally defined reasons where they must refuse to produce a prisoner even if there's a court order.
Yes, absolutely. An officer must abstain, they don't have a choice, from carrying out a court's production order in several clear situations.
Such as?
If the prisoner is medically unfit, serious sickness or infirmity, or if they are currently under committal for trial, or on a remand pending trial or investigation for another case.
Ah, so if they're tied up in another active proceeding.
Right, unless they are needed purely for giving evidence within a 25-kilometer radius of the prison. That's a specific exception.
Okay, 25 kilometers for witness testimony is allowed.
Yes. They must also abstain if the prisoner's current custody term is set to expire before the logistics of taking them to court and bringing them back can realistically be completed.
Makes sense.
And of course, if the prisoner is subject to one of those overriding government orders we just talked about under Section 303, in any of these refusal scenarios, the officer is legally required to send a written statement to the court explaining the reasons for abstaining.
Okay, let's try an illustration. High-profile terrorist in jail. Intelligence suggests moving them to court for a minor hearing could trigger an escape attempt or public chaos.
Right.
The central government might issue an order under Section 303 overriding any court summons for their physical presence. They might have to testify remotely, perhaps?
Exactly. Or, another scenario, court orders prisoner X to be produced. But the jail doctor provides a certificate saying X has severe pneumonia and is unfit to travel.
The jail superintendent must refuse.
Must abstain. They inform the court, citing the medical condition. Now, consider prisoner Y, who is under trial for a major murder case in City A. They're needed as a witness in a totally separate case in City B, which is 300 kilometers away.
Can the officer refuse?
Yes, the officer can abstain because Y is actively involved in another trial elsewhere. But if that court in City B was only 15 kilometers away, the officer could not use the ongoing trial reason alone because of that 25-kilometer exception for witnesses.
Wow, that's quite specific.
It is. So what's the takeaway? These sections clearly show a court summons isn't an absolute unbreakable command. There are critical, legally defined exceptions for health, for logistics, for ongoing proceedings, and even for overarching national security concerns. It really demonstrates a complex interplay of powers.
It's a balance between security and judicial access.
And while the government's power is recognized, courts have also stressed it shouldn't be arbitrary. They often scrutinize the reasons given for abstention, which raises that critical question again. How do we ensure this executive power to exclude a prisoner is always used transparently and judiciously, preventing any potential misuse to perhaps avoid accountability or obstruct justice?
Okay, so let's say a prisoner is allowed to come to court. How are they transported? Is it always a high-security convoy? And if they can't physically come, is there any other way for the court to get their testimony?
Right, it's that critical balance again, security versus judicial access. What's insightful here is the dual focus.
Hmm.
First, the strict emphasis on continuous, secure custody during transport, and second, the provision for remote examination as a practical alternative. It's about ensuring justice is installed.
So the code mandates that prisoners, when brought to court, must be securely transported, kept securely, and returned securely.
Precisely. Unless there's a valid reason for not producing them, like sickness, the prison officer's duty upon receiving a valid court order is crystal clear. They must arrange for the person to be taken to court at the specified time.
Okay.
And crucially, they must ensure the person is kept in custody, either in the court premises or nearby, until their examination is done or they're allowed to return. Continuous, secure custody is the watchword throughout the entire process.
And if physical production just isn't feasible, maybe due to health, security risks, or extreme distance, the code allows for commissions.
Yes, it explicitly clarifies that these rules about physical production do not limit the court's existing power to issue what's called a commission to examine a prisoner or witness.
What's a commission exactly?
It's essentially a formal request, usually directed to another judicial officer, to go and record the witness's testimony remotely, wherever they are confined. The rules for how these commissions work are detailed elsewhere in the code.
So it's a vital alternative.
A crucial alternative, yes. If physical production is impractical, too risky, or just unnecessary, a commission ensures the evidence can still be collected and presented formally.
Let's illustrate. Prisoner Z is ordered to court. The jail superintendent arranges a police escort. Z is carefully transported, kept in a secure court lockup or under constant guard during the hearing, and then escorted back to jail, always in custody.
Right. Now consider an elderly, seriously ill prisoner, P vital witness, but moving them poses a severe health risk.
They can't come physically.
So instead of ordering physical production, the court issues a commission. It appoints a magistrate who then goes to the prison hospital and formally records P's testimony right there. The evidence is captured despite the challenge.
So what does this mean for you? If you're a prisoner being taken to court, you'll be under constant supervision that's for security and procedure. If you're a witness who happens to be in prison, your testimony can still be heard even if you can't physically appear in court, ensuring justice doesn't get stuck.
And courts have recognized that modern tools, like secure video conferencing, can be very effective alternatives for recording evidence remotely in these situations. Which makes you wonder, as technology keeps advancing, how might remote testimony options further revolutionize how confined individuals participate in legal proceedings? Could it strike an even better balance between security, efficiency, and accessibility?
The art of evidence. Recording and presenting in BNSS.
All right, let's dive into this really big chapter on evidence, Chapter XE5. This is often where cases are truly won or lost, right?
Absolutely. It's the cornerstone.
Yeah. How is evidence actually gathered, recorded meticulously, and then presented in court under the new BNSS? Is it always like a word-for-word transcript, or are there different ways of doing it?
It's a critical area, and you can see the level of detail the BNSS dedicates to it. It's trying to balance that need for meticulous, accurate recording with, practical efficiencies. It aims for fairness while adapting to different types of cases, different complexities. We start with some fundamentals. Language barriers and ensuring the accused is actually present.
Right. So first, the state government decides the official language for the courts in that state, but not the high court.
Correct. The state government sets the language for all criminal courts within its jurisdiction, except the High Court, which maintains its autonomy. This is vital for making justice accessible to the local population.
And then, crucially, the code generally insists that evidence must be taken in the presence of the accused.
Yes, that's the general rule. All evidence taken during a trial or other proceeding must be in the presence of the accused.
That sounds like a fundamental fair trial.
All right.
Confronting your accusers.
It absolutely is. Allows the accused to hear the evidence directly, observe the witness, instruct their lawyer. However, there are practical exceptions built in.
Okay.
If the accused's personal attendance has been dispensed with, maybe they're very ill, or perhaps their conduct in court is completely disruptive,
Right.
then the evidence can be taken in the presence of their advocate instead. And significantly, The new code explicitly allows this to happen using audio-video electronic means, so embracing modern tech.
Video conferencing, essentially.
Yes. And there's also a very important special proviso for child victims in sexual offense cases.
Okay.
The court can take specific measures to prevent the child from having to directly confront the accused face-to-face to reduce trauma. But crucially, this must be done while still ensuring the accused's fundamental right of cross-examination is fully protected.
Balancing protection with due process.
Exactly. It addresses trauma reduction, but includes essential safeguards for the accused.
Okay, let's imagine the Maharashtra state government declares Marathi as the official language for its lower courts. So evidence there gets recorded in Marathi.
Right. Now, in a typical theft trial, all the witnesses would testify with accused X physically present in the courtroom. But if X becomes seriously ill and the court excuses their physical attendance, X's lawyer can still fully participate, maybe via a secure video link, hearing the evidence and cross-examining witnesses remotely.
And for that child victim example, a 10-year-old girl in a sexual assault case.
The court might use, say, a screen in the courtroom or have the child testify from a separate room via video link to shield her from direct confrontation. But the accused's lawyer, perhaps also participating remotely or from the main courtroom, still gets to fully cross-examine her, ensuring the accused's rights are met.
So what does this mean for you? You have that fundamental right to understand and challenge the evidence against you, whether you're there in person or through your lawyer, possibly via video. And vulnerable witnesses get crucial protection, but without sacrificing due process.
Indeed. And this modern approach, embracing virtual presence, aligns with court rulings that have accepted video conferencing, which does raise an important practical question. How do courts ensure these tech solutions truly uphold the spirit of presence? Does video always allow for effectively observing a witness's demeanor, those subtle nonverbal cues that can be so important for judging credibility?
Good point. So given these different scenarios, is the court always recording every single word, like a court reporter typing furiously? Or is there flexibility in how much detail gets captured?
That's a really important distinction. And what's insightful here is that the BNSS uses a graded approach to recording evidence.
Graded, meaning different levels of detail.
Exactly. It reflects the seriousness and complexity of the case. It aims for efficiency where possible, but demands accuracy and detail where it's really needed. It's about being pragmatic without sacrificing the substance of the testimony.
Okay, so for less serious cases, there's a simpler method, like for summons cases and maybe some inquiries.
Yes. For those, the magistrate makes a memorandum of the substance of the evidence, basically a summary of the key points in the court language, which they then sign.
Just the gist. Expedites things.
Right. Captures the essentials, not necessarily verbatim, but for more serious matters, the level of detail goes way up.
Like for warrant cases, the ones involving more serious offenses.
Correct. For warrant cases, the evidence has to be taken down in writing. This can be done by the magistrate themselves, or they can dictate it, or have a court officer type it under their direct supervision.
And you mentioned modernization here too.
Yes. Significantly, it may also be recorded using audio-video electronic means, especially if the advocate is present.
So a video recording of the testament.
Potentially, yes. And the format is usually a narrative summary. But the magistrate has the discretion to switch to a question and answer format for specific parts, especially during cross-examination where precision is critical. And again, it all gets signed by the magistrate.
Much more comprehensive for serious cases. Audio-video gives a more complete record. Q&A gives precision.
Exactly. And this same detailed method applies to sessions trials as well, those handling the most grave offenses. A meticulous written record, or audio-visual, usually narrative, but with discretion for Q&A, all authenticated by the presiding judge's signature.
Forming the crucial basis for potentially severe sentences and any appeals.
Absolutely. And then there are rules about the language of the record. If a witness testifies in the court's official language, it's recorded in that language. Simple enough.
But what if they speak a different language?
If practicable, the court can record it directly in that language. If that's not feasible, then a true translation into the court language is made, and that translation becomes the record.
And if it is recorded in another language?
A true translation into the court language must be prepared shortly thereafter and kept with the record. There's also a practical proviso. If evidence is given in English and none of the parties require a translation into the court language, the court can dispense with making that translation.
Balancing accuracy, accessibility, and practicality.
Precisely.
Okay, let's run through examples. Petty traffic violation. Summons case. Magistrate notes down the gist of the police officer's testimony, memorandum of substance,
Correct.
grievous hurt case, warrant case. Magistrate writes down the witness's full account. A crucial cross-examination bit might be recorded verbatim, Q&A style. Maybe the whole thing is even video recorded.
Yes, much more detailed.
And language. Court language is Hindi. Witness speaks English. It can be recorded in English with the proviso about parties not needing translation. Witness speaks Tamil. An interpreter provides a Hindi translation, and that Hindi translation goes into the record.
Exactly. So what does this mean for you? The level of detail in the court record scales directly with the seriousness of the case. Proportionate attention. And the multilingual rules are there to ensure language barriers don't block justice.
This graded approach seems logical.
It aligns with historical legal principles. But it does make you think, how will the increasing use of audio-video recording change how higher courts review evidence? Will they rely more on the video, potentially getting a richer sense of the testimony, including those nonverbal cues?
Interesting thought. So the evidence is recorded with varying levels of detail. Is that the end of it? Or does someone get to check if it's actually accurate? Like, read it back.
Oh, yes, absolutely. That's a critical step. The new code builds in layers of verification and context. It ensures the written record faithfully reflects what was said, and it even allows judges to note those subtle things demeanor that words alone can't capture.
Okay, so this part mandates reading the completed deposition back to the witness for them to verify or correct it.
Exactly. Specifically for warrant cases and sessions trials, the more serious ones. The recorded evidence must be read over to the witness in the presence of the accused or their lawyer. Any necessary corrections are made right then and there.
What if the witness disagrees with the record? Says, yeah, I didn't say that.
Good question. If the witness disputes the accuracy, maybe claims they said possibly, when the record says certainly, the magistrate or judge doesn't automatically have to change the original record. Instead, they can make a note of the witness's objection and add their own remarks about what they believe was actually said.
Noting the dispute rather than altering history.
Right. And also, if the witness doesn't understand the language the record is written in, it must be interpreted to them. It's all about accuracy and fairness.
And similar interpretation rules apply to the accused or their advocate if they don't understand the language the evidence is given in.
Yes, fundamental to a fair trial. If evidence is given orally in a language the accused, who is present, doesn't understand, it must be interpreted to them right there in open court. Same for the advocate if they don't understand. For documents, the court has discretion to interpret key parts needed for formal proof.
And then there's that fascinating point about recording demeanor.
Yes. The judge or magistrate must record any material remarks about the demeanor of the witness while they're testifying.
Why is demeanor important?
Well, how a witness behaves, are they nervous, evasive, overly confident, straightforward, can offer vital clues about their credibility. These recorded observations help the judge evaluate the testimony, and they're especially useful for appellate courts who only have the written record later on.
Okay, let's see this in action. Witness W finishes testifying. Their recorded statement is read aloud. W says, actually the date was the 15th, not the 16th. The judge corrects it.
Simple correction.
Another witness, Y, listens and says, wait, I said maybe, but the record says definitely. The judge, recalling the testimony, makes a note. Witness objects states they said maybe. Court's recollection is witness stated definitely.
Noting the objection and the court's observation. Perfect.
And if an accused only understands Bengali, any English testimony must be interpreted live for them.
Right.
And the judge might make a note like, witness appeared hesitant and repeatedly avoided eye contact when questioned about financial records, providing context for assessing credibility later.
Exactly. So what does this mean for you? These are your checks and balances. You can ensure the record's accuracy, you're guaranteed to understand what's being said through interpretation if needed, and the court considers the human element, the demeanor, not just the words on paper.
These seem like vital parts of ensuring a fair process.
They are. Mandatory reading over, interpretation, noting demeanor, these are established principles, which raises another modern challenge. In courtrooms, increasingly using video, how do you effectively capture and convey those subtle nuances of demeanor to appellate courts reviewing the case later who lack that direct in-person observation?
Video might capture some things, but maybe not everything a live judge observes. Okay, what about the accused's own statement to the court? When the judge questions them, how carefully is that recorded? And do higher courts, like the High Court, follow exactly the same strict rules for evidence?
Right. The accused statement under examination is a crucial part of the process. And what's striking here is the absolute rigor applied to recording that statement, which actually contrasts with the flexibility given to high courts in setting their own rules. It reflects their different functions.
Okay, so for the accused examination, the code demands a super detailed procedure, recording every question, every answer, plus verification.
Precisely. The standard is completeness. The whole of the examination, including every single question put to the accused and every single answer they give, must be recorded in full. This is typically done by the judge or magistrate directly or under their immediate direction.
Language.
If practical, it's recorded in the accused's own language. If not, then in the court's official language.
Under verification.
Yes, after it's recorded, it must be read over or shown to the accused or interpreted if needed. And critically, the accused gets the chance to explain or add to their answers at this stage.
A chance to clarify.
Exactly. Then it's signed by both the accused and the judge magistrate. And the judge magistrate adds a certification stating it's a full and true account of the examination. There's even a proviso for electronic examination signatures needed within 72 hours. But, important note, this super detailed procedure does not apply to summary trials.
Okay, so maximum care for the accused statement in regular trials, and if an interpreter is used during this.
The code explicitly states they are bound to state the true interpretation, a clear legal and ethical duty vital for accuracy.
And the high court gets more leeway.
Yes. The BNSS grant high courts the power to prescribe the manner for recording evidence, both witnesses and accused in cases before them, through their own general rules. This recognizes their superior status and allows them flexibility to adapt procedures as they see fit for their own workings.
So picture this. After the prosecution finishes, the judge examines the accused. Every question, did you see X, and every answer, no, I was at home, is painstakingly recorded.
Word for word, essentially.
Then that record is read back to the accused or interpreted. They might say, wait, when I said at home, I meant my parents' home. That clarification gets added. Then they sign, the judge signs and certifies.
Perfect. And if an interpreter was translating the judge's questions into the accused language, that interpreter is legally bound to be accurate.
Right. Meanwhile, a high court hearing, an appeal might have its own specific rules, perhaps using official stenographers for arguments or adopting different methods for recording evidence in its specific jurisdiction, potentially differing from the detailed lower court rules.
Exactly. So what's the takeaway? Your direct statement to the court during examination is treated with the highest level of scrutiny to ensure accuracy and fairness. Interpreter trustworthiness is legally mandated. And remember, how evidence gets recorded can change depending on which level of court you're in.
The accuracy of the accused's examination is clearly paramount.
It is. Which makes you think, how does the flexibility given to high courts potentially impact a standardized approach? Does it help tailor procedures effectively, or could it sometimes complicate consistency across the justice system?
What if a really key witness is, say, living abroad? Or maybe they're in India but too sick or frail to travel to court? Does the whole trial just grind to a halt?
Oh, no, not at all. And this is where the BNSS provides some really clever established solutions for getting evidence, even when physical presence just isn't feasible. It ensures justice doesn't get stalled by these kinds of logistical hurdles. We're talking about commissions again, but specifically for witnesses.
Okay, so a court can issue a commission to examine a witness if getting them to court would cause unreasonable delay, expense, or inconvenience.
Right. Exactly. Or, interestingly, it's mandatory if the testimony is needed from very high constitutional functionaries like the president, vice president, a governor, or administrator. The court shall issue a commission in those cases if their evidence is necessary.
Mandatory for them.
Okay. And there's a fairness provision, too. If the prosecution wants to examine one of their witnesses on commission, the court can actually order the prosecution to pay the accused's reasonable expenses for participating, including their lawyer's fees.
Leveling the playing field somewhat if the accused has to participate remotely or send their lawyer.
Precisely. It balances efficiency, justice, and practicality.
And the code is specific about who these commissions are sent to, depending on where the witness is.
Yes, very clear channels. If the witness is within the BNSS territory, it goes to the chief judicial magistrate, who can assign it to another magistrate. If they're elsewhere in India but outside BNSS jurisdiction, it goes to a court or officer notified by the central government. And if they're outside India, especially in a country with reciprocal arrangements.
Like the UK example earlier.
Exactly. It's sent in a specific form to the relevant court or authority there, following procedures prescribed by the central government. It facilitates that international cooperation.
And how does the magistrate receiving the commission actually execute it?
They either summon the witness to their court or, if necessary, they can go to the witness's location, like a hospital. Then, they take the evidence using the same procedures and powers as they would in a warrant case. So, same level of detail and safeguards.
Ensuring quality control even when done remotely.
Yeah.
And can the parties' prosecution and defense actually examine the witness during this commission?
Oh, absolutely crucial. Yes. They have options. They can submit written interrogatories, basically, a list of questions for the magistrate to ask the witness.
Okay.
Or, and this is important, they can appear themselves or send their advocate to conduct a live examination, cross-examination, and re-examination of the witness during the commission proceedings.
Upholding that vital right to cross-examine.
Absolutely essential for a fair hearing.
So once the commission is done, the testimony is recorded. What happens then?
The commission documents and the recorded deposition are sent back to the original court that issued the request. They're then made available for inspection by all parties.
So everyone can see what was said.
Yes, transparency. And that recorded testimony is then admissible as evidence in the trial, subject to all just exceptions, meaning it can still be challenged on relevance, hearsay grounds, etc. It can even potentially be used in later related proceedings if certain conditions are met.
And the trial court can pause things while this commission is happening?
Yes, the court can adjourn the main proceedings for a reasonable time to allow the commission to be executed and the evidence to be returned. Just a practical measure.
And finally, these rules also work in reverse. If a foreign court sends a commission to India.
Yes. The BNSS procedures for executing commissions, allowing party examination, and returning the evidence apply equally to requests received from specified Indian courts outside BNSS territory or from foreign courts where India has reciprocal agreements. It facilitates that mutual legal assistance.
Okay, let's revisit that UK example. Crucial witness for fraud case has moved to London. The Indian court issues a commission, sent through official channels. A UK court officer summons the witness. The Indian prosecution and defense lawyers can either fly to London to cross-examine the witness live during the commission, or they can submit written questions. The evidence is recorded meticulously under UK procedures, but adhering to the commission's requirements.
Okay.
That deposition, recorded in the UK, is sent back to the Indian trial court. Both sides get to inspect it. It's then formally read into evidence, but the defense can still raise objections. That part is irrelevant. That's hearsay.
Makes sense.
And conversely, if a UK court needs to examine a witness residing in Mumbai, they send a commission to India. The Mumbai CJM would then oversee its execution, following these BNSS rules, ensuring the request is handled properly.
Exactly. So what's the big picture for you? Justice is increasingly global. Whether a key witness is in Pune or Paris, the system has mechanisms to get their testimony. Trials aren't easily stopped by geography anymore. But critically, rigorous safeguards for examination and cross-examination remain firmly in place.
It's about adapting to a connected world.
It is, and it reflects the growing importance of international cooperation in legal matters, which always brings up that question of balance. How do countries manage national sovereignty while facilitating this essential cross-border legal assistance, ensuring foreign requests are handled effectively but also compatibly with domestic laws?
Right. Now, experts. We see them in so many modern cases, doctors, forensic scientists, financial analysts. Do they all really have to troop down to court every single time they write a report? Even for something routine.
Yeah.
Seems like a huge drain on their time.
You've hit on a major pain point in the traditional system, absolutely. And the new code, the BNSS, takes a notably pragmatic approach here.
How so?
Its main goal is to save valuable expert time, which is often highly specialized and in demand, while still making sure there's proper judicial scrutiny. It draws a really crucial distinction between routine, often undisputed expert reports, and those findings that are genuinely contested and require the expert's personal presence for cross-examination.
Okay, so for medical witnesses like a civil surgeon who did an examination or post-mortem, their deposition can be used without them having to come to court.
Generally, yes. If their deposition was properly taken and attested by a magistrate with the accused present, or recorded via a commission, it's admissible as evidence on its own. Saves the doctor a trip to court for potentially routine testimony.
Okay.
But, and this is the crucial safeguard, the court may still choose to summon them, and critically, it shall summon them if either the prosecution or the accused makes an application requesting their presence for cross-examination. The right to challenge is preserved.
Okay, so admissibility first, but summoning is mandatory if requested. What about identification reports by executive magistrates, like from a test identification parade, TIP?
Similar principle, the executive magistrate's tip report identifying a person or property is admissible as evidence. This streamlines getting the report formally into the case.
But there are caveats.
Yes, important ones related to the new evidence code, the BSA. If the tip report happens to contain statements that would otherwise be inadmissible under certain BSA sections, things that might hint at a confession made during the process, those specific statements don't become admissible just because they're in the tip report.
Ah, prevents backdoor admissibility.
Exactly. And again, the court may summon the magistrate and shall summon them if either party applies.
Okay. Now, what about reports from places like the Mint, government printing presses, forensic science labs, FSLs, or experts on questioned documents?
For specific gazetted officers in these highly specialized government bodies, their reports are also admissible as evidence directly. The court may summon the officer if it feels necessary.
But there are restrictions on summoning them.
Yes, two key ones. First, no officer can be summoned merely to produce the base records or raw data underlying their report. The focus is on their conclusions.
Okay, no fishing expeditions for internal data.
Right. And second, they generally cannot be compelled to give evidence based on unpublished official records or disclose the specific details of their testing methods without permission from their higher-ups, like the general manager or officer in charge. This respects official secrecy and expertise while still allowing their conclusions into evidence.
Got it. And then there's a broader category of listed government scientific experts: chemical examiners, explosives experts, fingerprint bureau directors, serologists.
Yes, a whole list of them. For these experts, too, their official reports are admissible as direct evidence. The court, again, may summon them if needed.
But here they can send someone else.
Yes, this is a very practical provision. If summoned, the expert may depute a responsible officer from their department who is familiar with the case to attend court and testify on their behalf, unless the court has specifically ordered the expert themselves to appear personally.
That offers a lot of flexibility, especially for busy senior experts.
It does. It covers much common forensic evidence.
Let's run through examples. Doctor's post-mortem report, properly recorded by a magistrate, can be tendered in court. Doctor doesn't need to come initially.
Correct.
But if the defense lawyer says, "We strongly dispute the time of death finding in this report," they can apply, and the court must summon the doctor for cross-examination on that point.
Exactly. The challenge triggers the summons.
Okay. Executive Magistrate's TIPI report says witness identified, accused, report admitted. But if the defense argues the parade procedure itself was flawed,
They can apply to summon the executive magistrate to question them about how the parade was conducted.
right. Mint officer's report says currency is counterfeit, report admitted. Defense lawyer cannot just demand the officer bring all the internal Mint manuals on counterfeit detection to court.
Not without specific permission, generally no. The focus is the report's finding.
And a chemical examiner's report finds poison in a sample. Report submitted. Examiner is tied up in another major trial. They could potentially send a qualified junior scientist from their lab who assisted with the analysis to depose in court instead.
Unless the court specifically demanded the examiner's personal presence, yes.
So what's the big picture for you? These rules mean potentially much quicker trials because many expert reports can come in as direct evidence, saves countless hours. But critically, you always retain that fundamental right to challenge the evidence by demanding the expert show up for cross-examination. Fairness is preserved.
It's about streamlining the routine to focus on the contested. It reflects the goal of expediting trials while keeping that crucial right to cross-examine intact. Which makes you wonder, how does this balance play out in practice? Does it truly achieve both efficiency and robust scrutiny, especially when dealing with complex, cutting-edge scientific evidence?
Right. Now, this next section, Section 330, this sounds like it could be a real game changer for speeding things up. This idea of no formal proof for undisputed documents and reports. What does that actually mean in practice?
You're absolutely right to flag this one. It is potentially a profound shift. It's aimed squarely at focusing precious judicial time only on the issues that are genuinely in dispute. It's a powerful tool designed to streamline trials and cut out a lot of unnecessary procedural delay.
Okay, so it sets up a mandatory admission or denial process. Parties have to say whether they accept the genuineness of documents and reports.
Yes, mandatory. Parties must include particulars of every document they rely on in a list. Then, soon after these lists and documents are supplied, the prosecution and the accused, or their advocates, shall be called upon to admit or deny the genuineness of each document.
Is there a deadline?
Yes, the code says no later than 30 days after supply, though the court can extend this time if there are good reasons stated in writing.
Okay, admit or deny within 30 days.
Yeah.
And then comes the really striking part about experts.
This is the kicker. A specific proviso states, no expert shall be called to appear unless the report is disputed by any party.
Wow. So if nobody objects to the expert's report, the expert doesn't have to come to court at all.
That's the implication. It completely shifts the onus. Instead of the prosecution having to formally prove every single document and call every expert, even if the defense doesn't really contest it, the burden shifts to the party who disputes it. If you don't dispute the expert report, the expert likely won't be summoned. It's a massive potential time saver for these busy professionals.
And what about the documents themselves? If their genuineness isn't disputed?
Then the code says the document may be read in evidence without proof of signature.
Meaning you don't need to call the person who signed it just to say, yes, that's my signature.
Exactly. It avoids that often perfunctory exercise for uncontested documents. Now, the court still retains the discretion to require proof of signature if it has specific concerns, but the default becomes admissibility without formal proof if undisputed.
Let's walk through an example. Prosecution files the police FIR, a seizure memo from the crime scene, and a ballistics report from an expert. The defense reviews them. They decide to admit the genuineness of the FIR and the seizure memo. And crucially, they do not dispute the findings in the ballistics report.
Right. What happens then?
Under this section, the FIR and the seizure memo can be read directly into evidence. No need to call the police officer who registered the FIR or the one who prepared the memo just to confirm their signatures.
Streamlined.
And because the ballistics report wasn't disputed, the ballistics expert does not need to be summoned to court to testify about their findings. That report can also be taken as evidence directly.
Huge efficiency gain. The trial can then immediately focus on whatever is contested, maybe the interpretation of those facts or other evidence entirely.
So what does this mean for you? Potentially drastically faster trials. If you don't actually challenge the authenticity of a document or the conclusions in an expert report, the court won't waste time on the formality of proving them. It's a very pragmatic approach, valuing efficiency and focusing on the real points of disagreement.
This significantly expands on older principles about admitting documents. Adding the expert report dimension is key. It raises a crucial question, though. While incredibly efficient, how do we ensure that all parties, especially those perhaps without seasoned legal counsel, fully grasp the significant consequences of admitting a document, or, maybe more subtly, not disputing an expert report? Are they always making a fully informed decision?
Ensuring understanding is key. Okay, what about things that seem like pure formalities? Does the court really need a live witness for absolutely every single procedural step?
No, thankfully not. And that's the practical beauty of these next few provisions. If we connect this to the bigger picture, it's all about discerning where direct oral testimony under oath and cross-examination is absolutely essential versus where a sworn written statement and affidavit can suffice. Especially for non-controversial or purely procedural matters, it saves enormous court time.
Okay, so one section allows facts about a public servant, if they're alleged in an application, to be given by affidavit at the court's discretion.
Yes. If you make an application to the court that includes allegations regarding a public servant's conduct, you, the applicant, may give evidence of those specific facts via an affidavit, and the court may, if it thinks it's appropriate, order the evidence to be given that way.
So it expedites consideration of those kinds of applications without needing full oral testimony right away.
Exactly. It helps with interlocutory matters. Then there's another provision for evidence that is of a purely formal character.
Formal character? Like what?
Think routine, undisputed procedural steps. Maybe confirming that a particular notice was dispatched on a certain date or that a specific form was filed. Things not usually central to the dispute itself.
Okay. And that can be done by affidavit too.
Yes. Evidence of a purely formal character may be given by affidavit. And that affidavit may then be read into evidence, again, subject to all just exceptions.
But like with the experts, there's a right to challenge.
Absolutely. The court may choose to summon the person who swore the affidavit, but critically, it shall summon them for cross-examination if either the prosecution or the accused applies. So it saves time for the routine stuff, but preserves the right to cross-examine if someone actually disputes the formal nature or the content of that evidence.
And the code is also specific about who can witness these affidavits being sworn and what needs to be in them.
Yes, crucial for reliability. Affidavits must be sworn before authorized people, a judge, judicial or executive magistrate, a commissioner of oaths, or a notary public.
Okay.
And the content rules are strict. Affidavits must be confined to facts within the deponent's personal knowledge. If a statement is based on belief, the affidavit must clearly state the grounds for that belief. You can't just say, I believe X. You have to say, I believe X because Y told me and Y was there.
Ground for belief. Got it. And the court can strike out irrelevant stuff.
Yes. The court has the power to strike out any scandalous or irrelevant material from an affidavit. It ensures they stay focused and appropriate.
Okay, let's illustrate. An accused person files an application alleging some misconduct by the investigating officer. Instead of immediately having to testify orally about it, the accused, as the applicant, could potentially submit an affidavit detailing those allegations, if the court allows.
Right. Streamlines that initial stage.
Or a court clerk whose only role was to formally deliver a non-contentious document to another office. They could submit a simple affidavit confirming the date and time of delivery, avoiding a court appearance for that purely administrative task.
Makes sense.
But if the fact of the delivery itself becomes disputed, we never received it, then that clerk can be summoned to testify and be cross-examined.
Exactly. And their affidavit would need to be clear. I personally delivered the document. Personal knowledge. Or maybe, I believe it was delivered because the dispatch register shows. Belief with grounds.
So what does this mean for you? For straightforward or preliminary issues, you might be able to use an affidavit, saving time and hassle. But the rules for these affidavits are strict. They need to be properly sworn, based on knowledge or stated belief, ensuring they're credible legal statements.
This approach aligns with past practices allowing affidavits in certain contexts, but it always raises that practical question for courts. How do you effectively draw the line? What truly constitutes formal character evidence suitable for an affidavit versus evidence that, even if seemingly simple, really requires the full scrutiny of live oral cross-examination?
That judgment call seems key. Okay, let's wrap up with these final, quite specific but interesting sections. What happens if someone has a previous conviction? How does the prosecution prove that formally? And what if an accused person just disappears, absconds? Or a crucial officer who wrote a report retires or gets transferred? Does the system just get stuck?
Not necessarily. These final provisions really show the BNSS trying to be resilient, trying to adapt to these real-world practical challenges. They ensure justice can keep moving even with absent individuals or changing personnel while still maintaining fairness.
Okay, so first, proving a previous conviction or acquittal. There are specific methods.
Yes, streamlined methods. You can use a certified extract of the sentence or order directly from the court's records.
Oh?
Or specifically for proving a conviction, you can use a certificate from the officer in charge of the jail where the person served time or the official warrant of commitment that sent them there.
But just the document isn't enough.
Correct. A crucial requirement in all cases is evidence linking the identity of the accused person currently in court with the person named in that previous conviction or acquittal document. You have to prove it's the same person.
Identity proof is key. Makes sense. Streamlines proving past outcomes, which is important for things like enhanced sentencing.
Exactly. Now, what about absconders?
Yeah, what if the accused just vanishes?
This is another exception to the rule about the accused needing to be present. If an accused person has absconded, and there's no immediate prospect of arresting them, the court is empowered to go ahead and examine the prosecution witnesses anyway and record their depositions in the accused's absence.
To preserve the evidence.
Precisely. Because witnesses might move, forget details, or even pass away over time. This recorded evidence can then be used against the accused if they are eventually arrested, but only if the original witness, the deponent, is now dead, incapable of testifying, cannot be found, or getting them back to court would cause unreasonable delay or expense.
Okay, strict conditions for using it later.
Yes, and there's a similar provision for grave offenses, punishable by death or life imprisonment committed by unknown persons. A high court or sessions judge can direct a magistrate to inquire and examine witnesses even before anyone is accused. Those depositions can then be used against someone later accused, again, if the original witness is unavailable. It's all about preventing evidence from being lost forever.
A vital tool, especially for complex or cold cases. Okay, now the big one, officer transfers and retirements. What if the police officer who wrote the seizure memo, or the forensic expert who wrote the DNA report, is no longer available?
This is a major reform aimed directly at tackling delays caused by this very common issue. The BNSS has a pragmatic solution.
What is it?
If a document or report prepared by a public servant, expert, or medical officer is needed as evidence, but the original officer who made it is unavailable, may be transferred, retired, deceased, can't be found, medically incapable, or even just bringing them back would cause significant delay.
Okay, lots of reasons for unavailability.
Then the court shall secure the presence of the successor officer, the person currently holding that post, or responsible for those records to depose on the document or report.
The successor steps in.
Yes, the successor provides continuity, verifying the document's official nature or explaining the standard procedures under which it would have been generated.
But wait, did we just discuss undisputed reports?
Exactly, and that crucial proviso applies here too. No official, not even the successor, shall be called unless the report is disputed by any party.
Ah, so if the report itself isn't challenged, you don't even need the successor to come.
Correct. That significantly streamlines things further. And another modern touch, the deposition of the successor officer, if needed, may be allowed through audio-video electronic means.
Efficiency upon efficiency.
It's a major attempt to deal with a crime.
Imagine standing at a crossroads where a single legal decision could irrevocably alter a life. Maybe a death penalty hanging in the balance, or a criminal appeal charting this really complex journey, or, the very impartiality of justice being questioned.
Yeah, exactly. These aren't just abstract ideas. They're the high-stakes realities shaped by the framework of our legal system.
Right.
And today, on the deep dive, we're going to try and cut through some of the complexity of India's newly enacted Bhartiya Nagrik Suraksha Sanhita 2023. We call it the BNSS for short.
BNSS, right.
Okay.
And it's more than just an update, isn't it? It feels like the whole foundation for criminal procedure.
It absolutely is. It underpins everything, really, from the moment a crime is suspected right through to the final verdict and, well, everything that happens after.
And you've asked us to unpack some really crucial bits, the safeguards and mechanisms built into this new Sanhita,
Right.
specifically focusing on chapters Sekekx, Eke-Aliwan, Ekeatinal, Ekete.
That's the plan. These chapters, they're all about ensuring fairness, accountability, and the integrity of justice. Really fundamental stuff.
So think of this deep dive as your essential guide, your way into understanding the procedural backbone of India's evolving criminal justice system.
Our mission really is to shed light not just on what the law says, you can read that, but why these sometimes intricate processes exist. How do they protect individual rights? What are the checks and balances? Some might even surprise you.
Yeah, and how does it all play out in the real world? What does it mean for actual cases, for actual people?
Exactly. We want you to grasp not just the letter of the law, but its spirit, its implications for justice.
Okay, let's unpack this then. Let's jump right into some of these really fundamental safeguards. Where should we start?
Let's start with Chapter XXX. It covers the submission of death sentences for confirmation. That's sections 407 to 412 of the BNSS.
Okay, death sentences. I mean, the gravity of that, it's immense, isn't it? The ultimate penalty.
It really is. And this chapter highlights just how cautious, almost reverential, the law is about it. Before a death sentence can ever be carried out, it has to go through this automatic, rigorous judicial review by a higher court, specifically the High Court.
Automatic. So it's not something the convicted person has to ask for.
No, not at all. It's not an option for them. It's a mandatory safeguard built right into the system. It happens regardless.
That sounds like a critical final check, a way to prevent, irreversible error.
Precisely. It ensures that the most extreme penalty isn't imposed without multiple, very careful layers of scrutiny.
So let's get into the details. Section 407, you said, mandatory high court confirmation.
Yes, that's the core idea. When a trial court, what's called a court of session, passes a death sentence, the entire proceedings, the whole file, gets submitted forthwith to the High Court for confirmation.
Forthwith, that sounds urgent, like immediately.
It means exactly that immediately, without delay. It signals real urgency. The moment the Sessions Court gives that sentence, the clock starts ticking to get it reviewed by the High Court. It's a priority.
And the person convicted? Where are they during this?
They remain in jail under the Sessions Court's warrant. And it's really important to understand this automatic referral is not the same as the accused's own right to appeal, which they also have.
Right, two different tracks.
Exactly. This is an inherent safeguard triggered by the trial court itself. The High Court's job here is twofold. Check the correctness of the conviction and the appropriateness of the death sentence itself.
So let's picture it. A Sessions Court in, say, Lucknow sentences someone to death for murder. Right away, the case files have to go to the Allahabad High Court for confirmation. The person stays in jail, the sentence just waits. Must be a very thorough review.
Oh, it is. The Supreme Court has repeatedly emphasized this. Think of cases like Bakhan Singh v. State of Punjab. The court highlighted these procedural safeguards, including High Court confirmation, as absolutely crucial to prevent arbitrary death sentences.
So it's not just a formality.
Not at all. Another case, Rajendra Prasad v. State of UP, clarified this explicitly. It's not a mere formality. The High Court has a positive duty to examine the merits itself. So, yeah, it's a deep dive, not just a rubber stamp.
That's a really powerful point. The High Court isn't just shuffling papers then, which I guess leads us to Section 408, the High Court's power for further inquiry or additional evidence.
Exactly. It shows the High Court is proactive. This section gives it a crucial, almost investigative power. It's not limited just to the original trial record.
What do you mean?
Well, if something feels incomplete or maybe new crucial information comes up that could affect guilt or innocence, the High Court can actively go looking for it. It has the discretion, the choice, to decide if a further inquiry or additional evidence is needed on any point.
How does that work in practice? Do High Court judges put on detective hats?
Not quite. They have two main options. They can conduct the inquiry or take the evidence themselves, right there in the High Court, or they can direct the original court of session to do it.
Okay.
And practically speaking, the convicted person doesn't necessarily have to be present during these specific inquiries unless the High Court says so. It's often about formal evidence gathering. The results then get certified and sent back up to the High Court.
So, for instance, if the High Court is reviewing a death sentence and thinks, hang on, there was this witness mentioned, but they were never actually examined.
Exactly. They can order that witness to be heard, either by the High Court itself or by sending it back down to the Sessions Court for that specific purpose. It shows the High Court isn't just a passive reviewer. It can actively plug gaps to prevent a terrible injustice, a real safety net in capital cases.
It's a significant power. Is it used often?
The Supreme Court, in Ramshankar Singh v. State of West Bengal, did caution that this wide power should be exercised sparingly and only when necessary for a just decision. So it's not about redoing the whole trial, but about addressing specific critical gaps that could change the outcome.
Which brings us neatly to Section 409. This sounds like where the High Court really shows its authority.
Yeah.
Wide powers to confirm sentence or annul conviction.
Absolutely. This section shows the plenary meaning, the absolute and complete nature of the High Court's review. It can basically re-examine the entire case, facts and law, and reach its own independent conclusions. It's not bound by what the Sessions Court found.
Wow. So what are its options? What can it actually do?
It's quite a menu. It can, of course, confirm the death sentence, or it can pass any other sentence the law allows, like reducing it to life imprisonment. It can annul the conviction altogether. It can convict for a lesser offense, or even a different offense if the evidence points that way.
Even order a whole new trial.
Yes, if the original proceedings were seriously flawed. Or it can acquit the accused completely if it finds the evidence just isn't strong enough.
That's incredibly broad power. It really does sound like they're retrying the case. Is there anything that limits when they make the final confirmation?
Yes, there's a crucial proviso. The High Court won't issue a confirmation order until the time limit for the accused to file their own appeal has run out, or if an appeal has been filed, not until that appeal is decided.
So it links the automatic review with the accused's own appeal, right?
Exactly. It harmonizes the two processes. Often they end up being heard together, which makes sense for a comprehensive final review.
So let's revisit that scenario. High Court reviews a death sentence for murder. Finds, okay, the accused caused the death, but the evidence only really supports, say, culpable homicide not amounting to murder, not full murder.
The High Court can change the conviction and sentence accordingly. If the trial had major procedural errors, maybe order a new trial, or if the evidence is just fundamentally unreliable, acquit.
So what does this all boil down to for someone facing that sentence?
It means the High Court acts almost like a super trial court specifically for death sentences. Judgments like Juman v. State of Punjab stress the High Court's duty to examine the case for itself and come to an independent conclusion. Another case, Bhimappa v. State of Karnataka, reaffirmed the duty to reappraise the entire evidence. The High Court really gets into the weeds. It's a significant safety net.
Given that immense responsibility, it makes total sense that Section 410 requires the confirmation or any new sentence to be signed by 2 judges. It shouldn't be one person's decision.
Precisely. It mandates a collegiate decision. In high courts with 2 or more judges, at least 2 judges must sign off on any order confirming a death sentence or passing a new sentence in these proceedings.
It ensures more eyes, more deliberation.
Exactly. Heightened scrutiny, collective wisdom. It reflects the profound stakes. Matters of life and death. It's not just a suggestion, it's mandatory, as confirmed in State of Maharashtra v. Sindhi alias Raman.
So if Justices X and Y are hearing it, and they agree to confirm, both have to sign. Simple as that.
Correct.
But what if they don't agree? Judges can have different opinions, right?
They can, and Section 411 provides the mechanism for that. Procedure in case of difference of opinion. It ensures there's no deadlock.
Okay, so how does it work?
If the high court judges on the bench hearing the confirmation are equally divided, say, 1 for confirmation and 1 against the case gets referred, it goes to another judge of that same high court or maybe even a larger bench. They review it, give their opinion, and the final judgment follows the majority view.
So a tiebreaker mechanism. Justice A says confirm. Justice B says acquit. It goes to Justice C, who hears it, gives an opinion, and that creates the majority.
Exactly. It prevents cases getting stuck in limbo. This procedure was reiterated in Union of India v. Harish Kumar as a way to ensure conclusive outcomes.
And finally, in this chapter, Section 412, prompt communication of the High Court's order. The decision needs to get back to the original court, right?
Absolutely critical for implementation. The High Court's decision can't just hang in the air. The proper officer of the High Court, usually the registrar, must, without delay, send a copy of the final order properly sealed and attested back to the Sessions Court.
And now with tech.
Yes, the BNSS explicitly includes electronic means now for efficiency. This makes sure the trial court is officially informed and can take the necessary consequential actions.
Like issuing the warrant for execution if it's confirmed.
Or, crucially, releasing the accused if the High Court acquits them. So, if the High Court confirms, the registrar emails and sends a hard copy to the Sessions judge, who then proceeds with the next steps, like issuing the execution warrant in due course.
Okay, so looking back at Chapter XX as a whole, Sections 407 to 412, it really is this robust, multi-layered process for death sentence review.
It absolutely is. It underlines the sheer gravity, the irreversibility of capital punishment, and builds in maximum judicial scrutiny before that ultimate penalty can be carried out. It's a powerful statement about the value placed on human life within the legal framework.
Right. So from that very specific high-stakes review, let's broaden out to the general landscape of appeals. That's Chapter XE1, Appeals, Sections 413 to 435 in the BNSS.
Correct. This chapter lays out the fundamental right to challenge judgments.
But it's not an automatic right for everything, is it? You mentioned it's statutory.
That's key. The right to appeal isn't inherent. It has to be explicitly granted by law, by the statute. But here's where things get really interesting, especially for you, the listener, because the BNSS significantly boosts the role of victims in this process.
Okay. How so? Let's start with Section 413. No appeal to lie unless otherwise provided. Victim's right to appeal.
So the general rule is first, no appeal from a criminal court's judgment or order unless the BNSS or some other law specifically says you can. This stops endless litigation, keeps things efficient.
Makes sense. But the victim part?
That's the crucial proviso, and it's a major evolution. Victims now have a statutory right to appeal against several outcomes. 1, an acquittal of the accused. 2, a conviction for a lesser offense than what the victim believes was committed. And 3, the imposition of inadequate compensation.
Wow. So it's not just the state anymore. The victim themselves can say, no, this acquittal was wrong, or this sentence was too light, or this compensation doesn't cover the harm.
Exactly. It moves victims from being just witnesses to being active participants in ensuring the final outcome feels just to them. It empowers them significantly.
Where do they file this appeal?
Their appeal goes to the same court that an appeal from a conviction in that case would normally go to, so they use the established appellate channels.
So if an accused is acquitted of grievous hurt by a sessions court, the victim can now directly appeal that acquittal to the High Court under Section 413. Same if the conviction was only for simple hurt or the compensation felt insultingly low. The victim has a real voice, a legal path.
Precisely. This shift was supported by thinking in judgments like National Commission for Women v. State of Delhi and clarified as a distinct right in Satyapal Singh v. State of Madhya Pradesh.
Okay, what about other specific types of orders? Section 414 deals with appeals from orders about security.
Yes, appeal from orders requiring security or refusal to accept, reject surety. This provides a specific way to appeal orders related to keeping the peace or good behavior. These aren't criminal convictions, but they can still seriously impact someone's liberty or finances.
Like being asked to furnish a bond.
Exactly. Appeals against these orders go to the Court of Session. This covers orders demanding security for peace or good behavior, and also orders where the court refuses to accept a surety someone proposes or rejects one they've already offered.
Why is this appeal important?
Because these are preventive measures, not punishments for a crime already committed. But they still restrict freedom or impose financial burdens. Having an appeal ensures fairness in these proceedings, too. So if an executive magistrate orders you to provide, say, a arrest 10,000 bond for keeping the peace, and you think it's totally unjustified or way too high, you can appeal to the Court of Session. Same if they reject your friend as a surety, saying they're unfit. This aligns with principles of procedural fairness highlighted way back in Madulamai v. Subdivisional Magistrate Munger.
Okay, so we know victims have new rights, and there are appeals for security orders. But for general convictions, where do you appeal? That's the core of Section 415, isn't it? Appeals from convictions, the hierarchical ladder.
Yes, this section maps it out clearly, based on who convicted you and how serious the sentence is. It creates a graded system.
So walk us through that ladder.
Right. If the High Court itself convicted you in its original jurisdiction, which is rare but possible, the appeal goes straight to the Supreme Court. If a sessions judge or additional sessions judge convicts you, or if any other court imposes a sentence of imprisonment for more than 7 years, the appeal goes to the High Court. That 7-year mark is a key threshold.
And for less serious cases, from magistrates.
If a magistrate, first or second class, convicts you, or if a sentence is referred to the Chief Judicial Magistrate, CJM, for potentially a higher sentence, or if you get a probation order, the appeal generally goes to the Court of Session.
And I remember you mentioning a special timeline for certain sensitive cases.
Yes, a really important point. For convictions involving specific sexual offenses listed in the BNSS Bhartiya Sanhita, the appeal must be disposed of within 6 months of being filed. This shows a clear legislative push for faster justice in these particularly sensitive and serious cases.
That 6-month timeline is significant.
Yep.
So, quick example. A magistrate convicts me, 2-year sentence. Appeal goes to...
Court of Session.
Sessions Court convicts me, 10-year sentence. Appeal goes to...
High Court. This tiered system ensures the right level of judicial review for different case severities. It affirms the value of appeal as a statutory right where evidence gets reappraised, as noted in Arun Kumar v. State of UP.
Makes sense. Now, what if someone pleads guilty? Can they still appeal? Section 416 addresses this. No appeal in certain cases when accused pleads guilty.
Right. If you voluntarily admit guilt, you generally lose the right to challenge the conviction itself. It's about streamlining things, but still checking the sentence.
So how does it work?
If you plead guilty and are convicted based on that plea. If the conviction was by the High Court, there's absolutely no appeal allowed. If it was by a sessions court or a magistrate, you can appeal, but only about the extent or legality of the sentence.
So you can't argue you didn't do it anymore, but you can argue the punishment was wrong.
Exactly. The thinking is a voluntary guilty plea means you accept the facts, but the sentencing part still needs judicial oversight to make sure it's not excessive or legally flawed.
Okay, so I plead guilty before magistrate, get 2 years. I can't appeal the guilty verdict, but I can appeal to the Court of Session saying 2 years is too harsh, or maybe the magistrate didn't even have the power to give that sentence.
Precisely. That distinction is key, as highlighted in cases like State of Gujarat, VAA, Pathan. Though Thippaswamy v. State of Karnataka hinted that if the guilty plea itself wasn't truly voluntary, that might be a ground related to the legality of the whole conviction process.
Interesting nuance. Now, what about very minor cases? Are courts flooded with appeals over tiny fines? Section 417, no appeal in petty cases.
This section aims to prevent exactly that. It promotes finality for trivial matters, saving court resources, basically no appeal by a convicted person if the sentence is only a very minor one.
What counts as petty or minor here?
The limits are specific. If the High Court imposed the sentence, no appeal if it's just imprisonment up to 3 months or a fine up to Rs 10,000 or both. If it's the Court of Session, imprisonment up to 3 months or a fine up to Rs 200 or both. If a JMFC, just a fine up to Rs 100, and if a magistrate in a summary trial, just a fine up to Rs 200.
Very specific thresholds. But what if there's a mix? Like a tiny fine and a day in jail?
Ah, good question. The crucial proviso says an appeal can be brought if any other punishment is combined with such a minor sentence. So your example holds. A magistrate fines you Rs 50, no appeal. But if they fine you Rs 50 and order 1 day of imprisonment, an appeal might be possible because that other punishment, imprisonment, is added. However, just ordering security or imprisonment if you don't pay the fine, or even multiple small fines that add up but stay within the limit, those don't automatically trigger the right to appeal. Ochevla v. State of Gujarat confirmed interpreting petty cases strictly by these limits.
Okay, clear. Now, flipping the coin. What if the state thinks the sentence is too light? Can they appeal for a harsher sentence? Section 418. Appeal by state government against inadequate sentence.
Yes, they can. The state government, or central government for cases handled by central agencies, can direct the public prosecutor to appeal a sentence on the grounds of its inadequacy.
Where does that appeal go?
To the Court of Session if the original sentence was from a magistrate, to the High Court if the sentence was from any other court. But, and this is really important, there are significant safeguards for the accused when this happens.
Right, because they could end up with a worse sentence. What are the protections?
When the state files an appeal for enhancement, the accused must be given a reasonable opportunity of showing cause against such enhancement. They get to argue why the sentence shouldn't be increased. And here's the really interesting part.
Yes.
The accused can also use this opportunity to plead for his acquittal or for the reduction of the sentence.
Seriously. So the state tries to increase the sentence, and the accused can turn around and argue they should be let off completely or get an even lighter sentence.
Exactly. It opens the door for the accused to re-argue their entire case, essentially. It's not just a one-way street towards enhancement.
That's a powerful counterrate for the accused. And I see the note here, similar to Section 415. There's a 6-month disposal target for these enhancement appeals in certain sexual offense cases, too.
Correct. Courts are advised to use enhancement powers sparingly, as noted in Nadella Venkatakrishna Rao v. State of AP, and the accused's right to plead for acquittal or reduction during this process was affirmed as a substantive right in State of MP v. Ghanshyam Singh.
Okay, what about appealing an acquittal? We touched on the victim's right, but what about the state? Section 419. Appeal in case of acquittal. You said it's an uphill battle.
It is. An acquittal carries a strong presumption of innocence, so overturning it isn't taken lightly. The procedures are specific and somewhat restrictive.
How does the state initiate it?
It depends. The district magistrate can direct the public prosecutor, PP, to appeal a magistrate's acquittal in serious cases, cognizable and non-bailable ones, to the Court of Session. For other acquittals from original trials or lower appellate courts, but not High Court or Sessions Court revisions, the state or central government directs the PP to appeal to the High Court.
Is there a filter? Can they just appeal any acquittal they don't like?
No, and this is crucial. An appeal against acquittal to the High Court by the government cannot even be entertained without the leave of the High Court.
Leave of the High Court. What does that mean?
It means the High Court does a preliminary check. The state has to apply for permission, basically showing there are decent grounds to even consider the appeal. Only if the High Court grants this leave can the full appeal proceed. It filters out weak or frivolous attempts to overturn an acquittal.
And private complainants. If I filed the case initially.
If the case started on a private complaint, the complainant can also appeal an acquittal. But again, only if the High Court grants special leave to appeal. There are time limits for this. 6 months if the case involved a public servant, 60 days for other cases, counting from the acquittal date.
And what if the complainant's request for special leave is denied?
Then the state cannot bring its own appeal on that same acquittal. It prevents trying again through a different route. One bite at the apple.
So this leave to appeal requirement really protects the finality of an acquittal.
It does. It ensures it's not easily disturbed. Courts have said they should only interfere with acquittals for substantial and compelling reasons, like in State of Rajasthan v. Sohan Lal. And remember, Satyapal Singh v. State of Madhya Pradesh clarified the difference between the state complainant appeals and the broader victim's appeal right under 413.
Okay. Now, Section 420 seems like a really specific but important scenario. Appeal against conviction by High Court in certain cases, reversing acquittal. What's this about?
This is a critical safety net. Imagine someone was acquitted by the trial court. The state appeals to the high court. Now, if the high court reverses that acquittal, convicts the person for the first time, A&D gives them a severe sentence.
Then what happens?
Then that person gets an automatic statutory right of appeal to the Supreme Court.
Automatic. Why?
Because their liberty is being seriously curtailed, death, life imprisonment, or 10+ years jail, for the first time by an appellate court. They were initially found innocent. This warrants a direct path to the highest court for one final review. It's different from the high court just confirming a conviction from below.
Got it. So accused X is acquitted by Sessions Court, state appeals. High court reverses, convicts X, gives 12 years. X can go straight to the Supreme Court under Section 420.
Exactly. It ensures at least one apex court review when liberty is severely impacted at the appellate stage, as highlighted in P. Ramachandra Rao v. State of Karnataka. A vital check.
And what if multiple people are tried together? Section 421, special right of appeal in certain cases for co-accused. Does one person's right help the others?
Yes, it ensures fairness and parity. If more than one person is convicted in the same trial, and an appealable judgment or order is passed against any one of them, then all or any of the persons convicted in that trial get a right of appeal.
Even if their own sentence was minor, maybe even falling under the petty cases rule?
Yes. This provision overrides other restrictions in the chapter, including the petty cases bar, Section 417. It levels the playing field for co-accused.
So A, B, and C tried together. A gets 6 months, appealable. B and C just get small fines of Rs. $50 each, normally not appealable. Because A can appeal, B and C also get the right to appeal their convictions and sentences under Section 421.
That's exactly right. Mangalal v. Manila confirmed this. If one has the right, they all do in that trial.
Okay, that makes sense for fairness. Now, some procedural points. Section 422. Appeal to Court of Session how heard? How are appeals managed within the Sessions Court?
This is mainly administrative. Appeals to the Court of Session are usually heard by the Sessions Judge or an additional Sessions Judge, ASJ. However, appeals coming from a magistrate of the second class might be heard by the Chief Judicial Magistrate, CJM. The Sessions Judge basically decides who hears what, distributing the workload.
And filing the appeal itself. Section 423. Petition of appeal. Formalities.
Pretty standard. Every appeal must be a petition in writing. It has to be presented by the appellant or their lawyer. And unless the court says otherwise, you have to attach a copy of the judgment or order you're appealing against. Basic paperwork to get the process started.
What if the person wanting to appeal is in jail? How do they manage that? Section 424, procedure when appellant in jail.
This is a crucial access to justice provision. Being imprisoned shouldn't stop you from appealing. An appellant who's in jail can simply give their appeal petition and any necessary copies to the officer in charge of the jail.
And the jail officer has to help.
Yes, that officer is legally obligated to forward the petition to the correct appellate court. It ensures prisoners can initiate appeals without needing direct access to lawyers or court registries right away. This aligns with fundamental rights principles, like those discussed in Sunil Batra v. Delhi administration.
That's really important. Okay, so the appeal is filed. Does the court have to hear every single one fully? Section 425. Summary dismissal of appeal. The initial filter.
No, appellate courts need to manage their dockets. This section lets them weed out appeals that are clearly without merit early on, but with important safeguards.
On what grounds can they dismiss it summarily?
If, after looking at the appeal petition and the original judgment, the court finds no sufficient ground for interfering, basically, even if they accept everything the appellant says, there's no reason to change the lower court's decision.
But they can't just dismiss it without hearing anything.
No, natural justice is key here. For direct appeals, filed under Sec 423 by the person or their lawyer, the court must give the appellant or their advocate a reasonable opportunity of being heard before dismissing summarily.
And for appeals coming from jail, under Sec 424.
Similar principle. A reasonable opportunity of being heard is required unless the court finds the appeal is clearly frivolous, or bringing the accused to court would cause disproportionate inconvenience. Even then, they can't summarily dismiss a jail appeal until the normal time limit for filing the appeal has expired. This gives a chance for proper legal help to maybe get involved.
So a hearing is pretty much guaranteed unless it's truly abusive or impractical.
Generally, yes, especially for direct appeals. The court can also call for the case records before deciding on summary dismissal, and sessions courts or CJMs must write down their reasons if they do dismiss summarily. There's even a fallback. if a jail appeal was summarily dismissed, but it turns out another properly filed petition, say from a lawyer the prisoner contacted later, was overlooked, the court can reconsider and hear the appeal. Cases like Sitaram v. State of UP stress the mandatory need for a hearing, while Dagdu v. State of Maharashtra advised using summary dismissal sparingly, especially in serious cases.
Okay, so if an appeal survives that initial filter and isn't dismissed summarily, what happens next? Section 426. Procedure for hearing appeals not dismissed summarily. This must be the full review process.
Exactly. Once an appeal is admitted for a full hearing, a clear, structured procedure kicks in to make sure everyone is heard and the case is looked at thoroughly.
What are the key steps?
First, notices. Mandatory notice about the time and place of the hearing goes out to the appellant, or their lawyer, the public prosecutor, the complainant, if involved, and the accused, if the appeal is challenging their acquittal or seeking a higher sentence. They also get copies of the grounds of appeal.
Everyone's kept in the loop. What about the case files?
The appellate court must send for the record of the case from the lower court. The only exception is if the appeal is only about the extent or legality of the sentence in that specific situation, the court might decide without the full record, but usually they want the whole picture.
And the hearing itself.
The court shall hear the parties. Both sides get to present their arguments based on the record. There's one restriction. If the appeal was filed only arguing about the sentence being too harsh, the appellant can't suddenly start arguing about other things like innocence without the court's permission.
So this is the core of a fair appeal notice, records, hearing both sides. Makes sense. This was emphasized in K. Pandurangan v. SSR Velusamy.
Now, Section 427, Powers of Appellate Court. This is where we see the full scope of what an appellate court can do. It's not just about fixing small errors, it's about ensuring justice is done comprehensively. The court has enormous power here.
How enormous? Can they completely change the outcome?
Pretty much. After looking at the record and hearing everyone, they have a wide range of options. They can, of course, just dismiss the appeal if they agree with the lower court.
Okay, but if they don't agree, what if it's an appeal against an acquittal?
Then they can reverse the acquittal, order more investigation, order a retrial, or even find the person guilty themselves and pass a sentence.
Wow. And if it's an appeal against a conviction?
They can reverse the conviction and sentence, acquitting or discharging the person. They can order a retrial. They can alter the findings, say, change a robbery conviction to theft while keeping the sentence the same or maybe reducing it. Or they can alter the nature or extent of the sentence. But critically, in an appeal by the accused, they cannot enhance the sentence.
Cannot enhance. That's
Yeah.
important. What about appeals by the state asking for enhancement?
In that case, the court can reverse findings, acquit, order retrial, alter the finding, or alter the sentence to either enhance or reduce it. They also have a general power to make any other just or proper order needed.
Are there limits on this enhancement power?
Yes, two crucial ones. A sentence cannot be enhanced unless the accused has had a chance to argue against it, like we discussed under Sec 418. And the appellate court cannot impose a punishment greater than what the original trial court could have legally imposed for that specific offense.
So the High Court, for example, really have a lot of muscle here. Reversing an acquittal and convicting is a big step, presumably used carefully.
Very cautiously, usually only if the trial court's decision was clearly perverse, meaning completely unreasonable based on the evidence. But the power to reduce sentences or change convictions shows the court's role in fine-tuning justice. Cases like Chandrappa v. State of Karnataka set out principles for interfering with acquittals, while Alamgir v. State, NCT Delhi, emphasized the power to reappraise all evidence.
Okay. Now, Section 428 deals with judgments of subordinate appellate court. Does this mean judgments from courts like the Sessions Court when they hear appeals?
Exactly. It basically says that when subordinate courts, like Sessions Court, CJM, act as appellate courts, their judgments must meet the same standards as original trial court judgments, written, reasoned, clear points, the decision, etc., following the rules in Chapter 29 of the BNSS. It also notes that the accused generally doesn't need to be physically present to hear the appellate judgment unless the court specifically asks for it. A practical point.
And Section 429 ensures the order of High Court on appeal to be certified to lower court. The decision needs to be officially sent back down, right?
Yes, it's not just an abstract ruling. The High Court must certify its judgment or order back to the court whose decision was appealed. The procedure specifies the route, for example, through the CJM for judicial magistrates. The lower court then must make orders that conform to the High Court's judgment and update its own records, ensures the loop is closed.
Makes sense. Now, this next one feels really important for the person convicted. Section 430, suspension of sentence pending appeal, release of appellant on bail. Can someone stay out of jail while their appeal is heard?
This is a crucial section protecting liberty, acknowledging a conviction isn't truly final until appeals are done. The appellate court can suspend the execution of a sentence and release the convicted person on bail or bond.
Is it automatic?
No, the court has discretion, and importantly, it must record its reasons in writing for granting suspension and bail. This ensures transparency. Also, for very serious offenses, those punishable with death, life imprisonment, or 10 years or more, there's an added safeguard. The public prosecutor must get a chance to argue against release before bail is granted.
So extra checks for serious cases. What about right after conviction? Can the trial court help someone appeal?
Yes, there's a really thoughtful provision here. The court that convicted you can grant short-term bail if the sentence isn't more than 3 years, or it was a bailable offense, and you were already on bail during the trial, specifically to allow you time to present your appeal to the higher court and get bail orders from them.
So it stops you being immediately jailed just because you were convicted, preventing that from blocking your ability to file the appeal paperwork.
Exactly. It's a practical bridge to access the appellate process. One more point. Time spent out on bail pending appeal doesn't count towards the sentence if the conviction is eventually upheld.
Right. So suspension and bail are possible, require reasons, have checks for serious cases, and the trial court can grant short-term bail to facilitate the appeal. Cases like Kashmir Singh v. State of Punjab noted it's unjust to keep someone jailed for a long appeal if they have a good case.
Correct. Factors like the nature of the offense, the evidence, the sentence length, and the prima facie merits of the appeal are considered, as mentioned in Anil Kumar Yadav v. State, NCT of Delhi.
What if the situation is reversed? An appeal against acquittal. Can the High Court make the accused, who is free, come back to court or even be detained? Section 431. Arrest of accused in appeal from acquittal.
Yes, the High Court needs that power. When an appeal against an acquittal is presented, and remember, leave might be required first, the High Court may issue a warrant for the accused's arrest.
To ensure they show up.
Exactly. Once arrested and brought before the court handling the appeal, usually the High Court here, that court can decide whether to commit them back to prison or grant them bail while the appeal against their acquittal is pending. This power is typically used after the court sees some initial merit, prima facie substance, in the appeal, ensuring the person is available if the acquittal gets overturned. But it's used cautiously, as advised in State of UP v. Pusu.
Okay. What if really crucial new evidence comes up during the appeal?
Yeah.
Evidence that wasn't there at the trial. Can the appellate court consider it? Section 432. Appellate court may take further evidence or direct it to be taken.
This is an important, though exceptional, power. The general rule is appeals are decided on the existing trial record. But if the appellate court thinks additional evidence is necessary for a just decision, it must record its reasons for thinking so. Then it can either take the evidence itself or direct a magistrate or sessions court, if it's the High Court hearing the appeal, to take it.
So it's not a free-for-all to redo the case.
Definitely not. It's not meant for parties to try and fix holes in their original case because they were negligent. It's for the court to ensure it has a complete picture when vital information was genuinely missing or unclear, and it's essential for justice. The accused, or their lawyer, has the right to be present during this evidence-taking, and normal trial procedures apply.
So maybe a crucial document surfaces that simply couldn't be found before despite all efforts? The High Court could order it presented?
Yes, potentially, but it's used sparingly, as Rambal v. State of Maharashtra emphasized, only if essential for a just decision. Though in exceptional cases like the Best Bakery case, Zahira Habibullah H. Sheikh v. State of Gujarat, courts have allowed it to prevent a total miscarriage of justice.
And what if the appellate judges themselves disagree? We saw this for death sentence confirmation. Does Section 433 cover divided opinions in general, appeals to? Procedure, where judges of Court of Appeal are equally divided.
Yes, it applies more broadly. If a High Court bench hearing an appeal is equally divided in opinion, the appeal, along with their differing written opinions, goes before another judge of that court. That third judge hears it, delivers their opinion, and the judgment follows the resulting majority.
Same tiebreaker mechanism. Ensures a final decision.
Right. And there's a proviso. If any of the judges think it's necessary, the appeal could even be reheard by a larger bench. Union of India v. Harish Kumar confirmed this as standard procedure.
Okay, bringing us toward the end of appeals. Section 434. Finality of judgments and orders on appeal. Are appellate judgments the absolute end of the road?
Generally, yes, they bring finality. But there are specific exceptions. Appellate judgments are final except for situations covered by other provisions, like state appeals against sentence, Sec. 418, state victim complainant appeals against acquittal, Sec. 419, reconsideration of summarily dismissed jail appeals, Sec. 425-4, and importantly, the powers of reference and revision in Chapter 32.
So, final at that level, but other avenues might exist. What about related appeals from the same case?
Good point. A crucial proviso says that even if, say, an appeal against conviction is decided, the appellate court can still hear and dispose of a pending appeal against acquittal, Sec. 419, or for enhancement of sentence, Sec. 418, that arises from the same original case. This ensures all angles of a single judgment are considered, preventing conflicting outcomes. State of Kerala v. KSMMA Manikandan touched on this comprehensive approach.
And the last, rather grim point, Section 435, abatement of appeals. What happens if someone involved in the appeal dies?
Yeah, it's a practical necessity. Criminal proceedings are generally personal, so if the accused dies during an appeal by the state against acquittal or for sentence enhancement, that appeal finally abates. It just terminates. The point is moot.
What if the appeal was filed by the convicted person and they die?
Generally, that appeal also finally abates. The main exception is if the appeal was only against a sentence of a fine. In that case, the appeal doesn't abate because the fine could potentially still be recovered from the deceased person's estate if the appeal fails.
But is there any way to continue an appeal if the person convicted of, say, imprisonment dies? Maybe to clear their name?
Yes, and this is a really significant and compassionate proviso. If the appeal was against a conviction resulting in a sentence of death or imprisonment, and the appellant dies, any of their near relatives can apply within 30 days to the appellate court for leave to continue the appeal.
To clear the family name?
Exactly. A criminal conviction carries a huge stigma and can have other consequences too, even after death. This allows close family defined as a parent, spouse, lineal descendant, child, grandchild, brother, or sister to pursue the appeal to try and overturn the conviction itself.
That feels profoundly important. It acknowledges the impact beyond just the individual.
It really does. This right for relatives was recognized in cases like Harnam Singh v. State of HP, and Bandara Gajapathy Rao v. State of AP confirmed that appeals against fines don't abate. So the law tries to balance the personal nature of punishment with the lasting impact of a conviction.
Okay, that wraps up appeals. A complex but crucial area. Now let's shift gears slightly to Chapter 32. Reference and revision, sections 436 to 445. You described this earlier as the watchdog role of higher courts.
That's a great way to think about it. This isn't about a standard appeal where someone challenges the whole verdict. It's more about higher courts supervising lower courts, checking for errors of law, jurisdiction, procedural mistakes, even when an appeal wasn't filed, or maybe wasn't even possible. It's about ensuring correctness, legality, and consistency across the board, supervisory justice.
Let's start with section 436, reference to high court. What is a reference? Is it like a lower court asking the high court for help?
Sort of, yes. It's a mechanism for subordinate courts to get definitive rulings from the High Court on important legal questions, particularly about the validity of laws.
Validity of laws. How does that work?
There are two parts. First, there's a mandatory reference. If a lower court is handling a case and believes it involves a question about the validity of any act, ordinance, or regulation, or part of one, and that law hasn't already been struck down by a higher court, ND deciding that question is essential to resolve the case, well, then the lower court must refer that question to the high court. They send it up with their own opinion and reasons.
So lower courts can't just decide on their own that a law is invalid. They have to ask the high court. Preserves hierarchy.
Exactly. It prevents chaos and ensures uniformity. Then there's also a discretionary reference. A court of session facing any question of law, not necessarily about validity that's complex, or arises in a pending case, may refer it to the high court for guidance. While the reference is pending, the accused can be kept in jail or released on bail.
So an example. A magistrate is trying someone under a new state law. The defense argues a key section violates the Constitution, and no higher court has ruled on it yet. The magistrate must refer this constitutional question to the high court.
Perfect example. Or a sessions judge facing a really novel point of legal interpretation during a trial might choose to refer it for clarity. This principle of referring substantial legal questions upwards is fundamental, like illustrated in spirit by things like INRI, the Special Courts Bill, 1978.
And once the high court decides on the reference, section 437, disposal of case according to decision of high court.
The high court's decision is binding. Simple as that. The High Court passes its order, sends a copy back down, and the referring court shall dispose of the case conformably to the said order. They have to follow the High Court's ruling. The High Court might also order costs related to the reference.
Okay, clear. Now let's get into revision. Section 438. Calling for records to exercise powers of revision. This sounds like the core supervisory power.
It absolutely is. This establishes the revisional jurisdiction of both the High Court and the Sessions Court. It's their power to check the work of lower courts, separate from the appeal process.
How does it work? What triggers it?
The High Court or a Sessions judge can, on their own initiative or on application, call for and examine the records of any inferior criminal court within their jurisdiction.
Why would they do that? What are they looking for?
The purpose is stated clearly: to satisfy themselves about the correctness, legality, or propriety of any finding, sentence, or order passed by the lower court, and also the regularity of any proceedings.
Yeah.
Basically, did the lower court act correctly, legally, appropriately, and follow the proper procedures?
And they can pause things while they look.
Yes, they can suspend the execution of the sentence or order and release the accused on bail or their own bond while the revision is pending.
You mentioned inferior court. Who is inferior to whom here?
For the purposes of revision by a sessions judge, all magistrates, executive and judicial, original or appellate, within that sessions division are considered inferior. Now, a hugely important point in this section is the bar on revising interlocutory orders.
Interlocutory orders, what are those?
These are orders made during the course of a trial or proceeding that don't finally determine the rights of the parties. Think of things like granting or refusing an adjournment or allowing a particular witness. Section 438 says the powers of revision cannot be used to challenge these kinds of orders.
Why not?
To prevent trials from being constantly interrupted and delayed by challenges to every minor procedural ruling, it ensures the main case can proceed smoothly. This was a major point of discussion in cases like Amarnath v. State of Haryana and Madhulame v. State of Maharashtra.
Makes sense. And there's another bar about applying to both courts.
Yes, the bar on successive applications. If you make an application for revision to either the High Court or the Sessions Judge regarding a particular matter and it's decided, you cannot then make another application about the same matter to the other court.
Prevents forum shopping or trying to get a second opinion if you didn't like the first revisional decision.
Exactly. So revision is often used when no appeal is available, perhaps against an order that seems illegal or improper but isn't a final judgment. It's a discretionary power aimed at correcting miscarriages of justice, but filtered by these bars on interlocutory orders and successive applications.
Okay. What about cases that were stopped early, like a complaint dismissed or an accused discharged by a magistrate? Can revision help there? Section 439. Power to order inquiry.
Yes, this section provides a way for higher courts, High Court or Sessions Judge, to look into situations where a case was terminated perhaps prematurely at the magisterial level if that termination seems wrong.
So how does it work?
Upon examining the records, or based on other information, the High Court or Sessions Judge can direct the Chief Judicial Magistrate, CJM, to conduct a further inquiry into either a complaint that was dismissed under specific sections like 226 or 227-4 BNSS, or the case of any person who has been discharged.
Further inquiry? Does that mean starting the whole case again?
Not necessarily a full fresh trial. Rajesh v. State of Haryana clarified it usually means a re-examination of the matter, perhaps looking at the evidence again or considering points missed. But there's a vital safeguard here. No direction for a further inquiry can be made regarding a person who was discharged unless that person has first been given an opportunity to show cause, basically, to argue why the discharge was correct and no further inquiry is needed. Natural justice again. This power is used when the dismissal or discharge seems illegal or improper, as noted in Mohanlal Maganlal Choksi v. State of Gujarat.
Got it. Now, the Sessions Judge themselves have revisional powers. Section 440. Sessions Judge's powers of revision. How extensive are these?
They're quite extensive. For the records they call for under Section 438, the Sessions Judge can exercise pretty much all or any of the powers that the High Court has under Section 442(1, which we'll get to shortly. This includes wide, appellate-like powers, even the power to tender a pardon. They are a significant revisional authority at the district level.
But there's a catch regarding finality, isn't there?
Yes, a very important one for the person applying. If you apply for revision to the Sessions Judge, whatever decision the Sessions Judge makes on your application is final for you. You cannot then file another revision application about the same thing to the High Court or any other court.
So you get one shot at revision, Either the sessions judge or the high court, but not both if you're the applicant.
That's the gist. It provides an accessible district-level remedy, but prevents parties from having multiple bites at the revisional cherry. However, this finality for the applicant doesn't stop the High Court from using its own sua motu power, acting on its own, or hearing a revision filed by a different party, like the state. Jagannath Chaudhary v. Ryan Singh discussed this scope.
And Section 441 just clarifies that additional sessions judges can also exercise these revisional powers if cases are transferred to them by the main sessions judge.
Exactly. It's an administrative provision for workload distribution, ensuring ASJs have the same authority for the cases assigned to them.
Okay, now the big one. Section 442, High Court's powers of revision. This is the apex supervisory power, right?
It is. The High Court's revisional jurisdiction is its broadest supervisory tool. It allows it to step in and correct substantial injustices, errors of law, or procedural irregularities by any subordinate court, either because someone applied or entirely on its own initiative.
How does it get triggered?
Either from records it specifically called for under Sec 438 or from information that otherwise comes to its knowledge. That's the sua motu power the court can act based on, say, a news report or information received informally, if it suggests a serious miscarriage of justice.
And what can it actually do in revision?
Its powers are very wide. It can exercise any of the powers that an appellate court has, under sections like 427 for judgments, 430 for bail, 431 for arrest and acquittal appeals, 432 for additional evidence. It can also exercise powers a sessions court has, like tendering a pardon, Sec. 344. If the High Court judges hearing the revision are equally divided, the tiebreaker procedure, Sec. 433, applies here too.
Are there crucial safeguards or limitations on this broad power?
Absolutely vital ones. First, natural justice. No order that prejudices someone can be made unless he has had an opportunity of being heard, either in person or through their lawyer. Second, and this is fundamental, nothing in this section shall be deemed to authorize a high court to convert a finding of acquittal into one of conviction.
That again. So the High Court, in revision, absolutely cannot find someone guilty if they were acquitted by the lower court.
Cannot. That requires a proper appeal against acquittal, like under Sec. 419. Revision can be used to correct errors in a conviction, maybe alter the sentence, order a retrial, or point out flaws in an acquittal, but it cannot flip an acquittal into a conviction. This was explicitly stated in K. Chinnaswamy Reddy v. State of Andhra Pradesh.
Any other limitations?
Yes, similar to the sessions judge's power, if an appeal could have been filed against the order but wasn't, the High Court generally won't entertain a revision petition from the party who could have appealed. Revision isn't meant as a backdoor substitute for a missed appeal.
But what if someone genuinely didn't know an appeal was possible?
The High Court has flexibility. If someone files a revision mistakenly believing no appeal was available, the High Court may, in the interests of justice, treat that revision petition as if it were an appeal and hear it on its merits. But generally, revision is seen as an exceptional remedy for glaring defect or manifest error, not just the second chance appeal, as noted in Pranab Kumar Mitra v. State of West Bengal and Amit Kapoor v. Ramesh Chandra.
Okay, now Section 443 deals with a specific situation. Power of High Court to withdraw or transfer revision cases. What's this about?
This handles potential conflicts when different people convicted in the same trial file revision petitions in different courts. Maybe one goes to the High Court while others go to the sessions judge.
To avoid different courts possibly reaching different conclusions on the same case.
Precisely. The High Court acts as the arbiter. It decides which of the two courts should finally dispose of the applications, considering factors like convenience and the importance of the legal questions involved. It can then transfer the applications, for example, pull the Sessions Court applications up to itself or send its own down, to ensure they are all heard together or in the most appropriate forum. And again, if a case is transferred to and decided by the Sessions Judge under this section, that decision is final for the applicant.
Makes sense for consistency. What about the right to be heard orally in revision? Does it guarantees like in appeals? Section 444, option of court to hear parties.
Generally, no. Unlike appeals, the law states that, save as otherwise expressly provided, no party has any right to be heard before any court exercising its powers of revision. However, it immediately adds, but the court may, if it thinks fit, hear any party.
So it's discretionary.
It's largely discretionary. But remember, Section 442(2) mandates a hearing if the High Court is considering making an order that would be prejudicial to someone. So while there's no automatic right to an oral argument in every revision case, natural justice kicks in when potential adverse orders are on the table. Courts often do hear parties anyway as a matter of fairness, as noted in Pranab Kumar Mitra.
And finally for this chapter, Section 445, High Court's order to be certified to lower court. Similar to appeals, the revisional order needs to go back down.
Yes, the process mirrors appeals. The revisional court, high court or sessions judge, must certify its decision or order back to the court whose order was revised, following the same procedure as Section 429 for appeals. The lower court then must make orders conformable to that decision and amend its records. It ensures the supervisory judgment has practical effect.
Okay, we've covered death sentence confirmation, appeals, and reference and revision. That leaves one more crucial area from our initial plan. Chapter 33, Transfer of Criminal Cases, Sections 446 to 452. This sounds like it's all about ensuring a fair trial location.
Exactly. This chapter is fundamentally about ensuring justice is not only done, but seen to be done. It provides ways to move criminal cases and appeals from one court to another if there are serious concerns about fairness, impartiality, or sometimes even just convenience. The pursuit of impartiality in action.
Let's start at the top again.
Yeah.
Section 446, Power of Supreme Court to transfer cases and appeals. This must be for the most significant transfers.
Yes, this is the ultimate power, specifically for transferring cases across state lines, interstate transfers, or between different high courts. The Supreme Court can do this if it deems it expedient for the ends of justice.
Across state lines, why would that be needed?
Think about situations where local prejudice in one state is so intense that a fair trial seems impossible. Or maybe there are threats to witnesses or the accused, or the case involves complex issues with national implications that are better handled elsewhere. The Supreme Court can transfer a case from one high court to another, or from a court under one high court to a court of equal or higher status under another high court.
Who can ask for such a transfer?
Only the Attorney General of India, a top government lawyer, or an interested party, typically the accused or sometimes the prosecution or victim, who must usually file an application supported by an affidavit detailing the reasons.
Is there a check against misusing this power? Filing frivolous applications just to delay things?
Yes. If the Supreme Court finds an application is frivolous or vexatious, meaning baseless or intended to harass, it can order the applicant to pay compensation to the party who opposed the transfer. This power is used sparingly, reserved for situations where there are compelling circumstances justifying such a drastic step, as stated in K. Ambazagan v. Superintendent of Police. Mere suspicion isn't enough. You need reasonable apprehension based on tangible material, according to Nahalchant Laluchan PT, LTD Vitalianem Thevar.
Okay, that's the Supreme Court for interstate transfers. What about transfers within a state? That's Section 447, Power of High Court to transfer cases and appeals.
Right. The High Court has extensive powers to transfer cases within its own jurisdiction, intrastate transfers, for similar reasons ensuring fairness, dealing with complex legal issues, or sometimes for the general convenience of parties and witnesses.
What are the specific grounds the High Court can consider?
The section lists several. If a fair and impartial inquiry or trial cannot be had in the current court, if a question of law of unusual difficulty arises, if a transfer would be for the general convenience of parties or witnesses, though justice usually outweighs convenience, if it's generally expedient for the ends of justice, or if another part of the BNSS requires it.
And what kind of transfer orders can the High Court make?
It can transfer a case to another subordinate court of equal or superior jurisdiction, commit a case for trial to a court of session, or even in rare cases, transfer a case to itself and try it directly.
Who can initiate a transfer application to the High Court?
It can be based on a report from the lower court itself, an application by an interested party, or the High Court can act suo motu on its own initiative.
Is there a hierarchy? Do you have to try the local options first?
Yes, there's an important proviso. If you want to transfer a case within the same sessions division, VRXG, from one magistrate to another in the same district, you generally cannot apply directly to the High Court unless you have first applied to the sessions judge for that transfer and your application was rejected. You have to exhaust the lower remedy first.
And similar procedural safeguards apply. Affidavits, notice, stay of proceedings, compensation for frivolous applications.
Yes, those are all built in, similar to the Supreme Court process. So, for example, if a case in District X is being heavily influenced by powerful local figures, an interested party could apply to the High Court after potentially trying the sessions judge first, if it's within the same division, to move it to District Y for a fair trial. Or the High Court might consolidate several similar cases, raising a complex legal point to be heard by one specific court, or even itself. The paramount consideration is the administration of justice, as Gurcharan Das Chadha v. State of Rajasthan put it.
Now, taking it down to the district level, Section 448, powers sessions judge to transfer cases and appeals. This is for transfers within that judge's own division.
Exactly. This provides a localized mechanism. The sessions judge can order the transfer of any case from one criminal court to another within his sessions division if they find it expedient for the ends of justice.
Same triggers, lower court report, party application, suo motu.
Yes, same triggers. And many of the same procedural rules apply application, usually supported by affidavit, notice to the public prosecutor, power to stay proceedings in the original court, and power to order compensation for frivolous applications, though the cap here is specified as not exceeding 10,000 rupees.
So if an accused person feels the magistrate hearing their case in Town T is biased, they can apply to the sessions judge of that division to transfer the case to different magistrate, say in Town U, within the same division.
Correct. But like all transfer powers, it's exercised with due care and caution, as KP2RE v. State of MP emphasized.
What about pulling cases back? Section 449. Withdrawal of cases and appeals by sessions judges. Can the sessions judge take back cases they assigned?
Yes, this reflects their administrative and judicial supervision role. A sessions judge can withdraw or recall any case or appeal they had previously made over, assigned to a chief judicial magistrate. They can also recall a case or appeal made over to an additional sessions judge, but with a time limit, only before the trial or hearing is actually commenced before that ASJ.
Why the time limit for ASJs?
To minimize disruption. Once a trial is properly underway, pulling it back can cause significant delays and inconvenience. After withdrawing a case, the sessions judge can either handle it themselves or reassign it to another competent court within their division. It's useful for managing workload or if circumstances change, like a judge becoming unavailable.
Makes sense. And similar withdrawal powers exist among magistrates. Section 450. Withdrawal of cases by judicial magistrates.
Yes, primarily for the Chief Judicial Magistrate, CJM, managing their subordinate judicial magistrates. A CJM can withdraw any case from a magistrate under them and either try it themselves or refer it to another competent magistrate. Also, a judicial magistrate who originally made over a case, if empowered to do so by the CJM, can recall that specific case and try it themselves. Again, it's about workload management and ensuring cases are handled appropriately.
And this applies to executive magistrates, too, for their specific types of cases.
Yeah.
Section 451, making over or withdrawal of cases by executive magistrate.
Yes, it mirrors the structure. District magistrates, DM, or subdivisional magistrates, SDM, can make over proceedings they started to a subordinate executive magistrate. They can also withdraw cases they previously made over and either deal with it themselves or refer it to another subordinate executive magistrate. Useful for handling public order or preventive cases officially.
Okay, one final piece here. Section 452, reasons to be recorded. This sounds like a crucial accountability check on all these transfer and withdrawal powers.
Absolutely crucial. Whenever a sessions judge or a magistrate makes an order under any of these transfer or withdrawal sections, 448, 449, 450, or 451, they must record their reasons for doing so.
Why is that so important?
It ensures transparency. It demonstrates that the decision wasn't arbitrary, but based on valid grounds related to the ends of justice or administrative needs. It forces the judge to articulate why the transfer or withdrawal is necessary. And, importantly, it allows a higher court to review the decision if it's challenged, because the reasoning is right there on the record. As KP2RE noted, reasons should show an application of mind.
Wow, okay. We've really covered a lot of ground there, from the gravity of death sentence confirmation through the multi-layered appeal system, the supervisory powers of reference and revision, right down to the mechanisms for transferring cases to ensure fairness. It's quite an intricate structure.
It really is. And what stands out, I think, is this deep underlying commitment woven throughout these chapters, a commitment to thorough judicial scrutiny, to accountability, and to protecting individual rights within that criminal procedure framework. It's not just about processing cases, it's about this complex dance designed to achieve justice at each step.
It definitely paints a picture of a system trying to be responsive, careful, and comprehensive, especially with the changes in the BNSS.
I think so. It aims for that balance.
So, for everyone listening, you should now have a much clearer picture of this procedural architecture, how it protects rights and guides the path of criminal justice in India under this new Sanhita.
Hopefully, yes. Understanding these procedures is key to understanding how justice operates.
So here's a final thought to leave you with. We've seen all these layers of review and oversight: the mandatory high court check on death sentences, the victim's expanded right to appeal, the high court being strictly barred from turning an acquittal into a conviction during revision, and the ultimate power of the Supreme Court to move cases across the entire country if needed for the ends of justice. Does this new BNSS framework strike an even more robust balance than before between keeping the system efficient and the absolute unyielding pursuit of a fair and impartial trial for every single individual?
That's the big question, isn't it? How this all plays out in practice.
What new questions does this deep dive raise for you about how justice is evolving? Something to think about.